ಬಂದ್ಮೇಲೆ ಕರೆ. Held it this way. A petition under section 482 of the CRPC calling in question the entire proceedings before the concerned court initiated under the Protection of Women from Domestic Violence Act would be maintainable only if proceedings are challenged on the ground of abuse of the process of the law. As the Court of Session is not empowered to obliterate the proceedings, holding it to be an abuse of the process of the law in an appeal. Any specific order passed by the concerned court answering applications under section 18, 19, 20 of the Act or any other interlocutory order would not be maintainable before this court in its jurisdiction under 48 of the CRPC. The aggrieved by any order has to prefer an appeal under section 29 of the Act as it is an alternative and statutory remedy available. Finding the entire process initiated in the instant case by the respondent against these petitioners, the father-in-law and the mother-in-law, to be an abuse of the process of the law, those proceedings are obliterated. So that there's some clarity now. Yes. Because section 29 says any order. Now, abuse of the process of the law, the court does not have. Yes. We'll release it by evening. Yes.
Number 2.
Criminal petition is allowed. The proceedings in so and so stands quashed. Yeah, 376 ತಾನೇ ಇದೆ.
Number 3.
Criminal petition is allowed. The proceedings in CC 19072 pending before so and so stands quashed co the petitioner. It is made clear that the observations made in the course of the order are only for the purpose of consideration of the case of the petitioner under section 48 of the CRPC. It shall not bind or influence any proceeding against any other accused pending before any other fora. Next.
4.
There is no warrant. This is one more. Dismissed. Just petition ಆಗ್ತೀರಾ? What is this? Yes. Well, I have dismissed it. Yes. I think I've said that also. 1 minute, I'll see. ಇಲ್ಲ ಪರವಾಗಿಲ್ಲ. Dismissed, yes.
5. Seal number 5.
Nataraj, take him back. Right to practice. I've said your welfare fund will not control the Advocates Act. Welfare Fund Act, though. What practical difficulty? He will refund everything. We have said so. Writ petition is allowed. The endorsement dated so and so of the Karnataka State Bar Council stands quashed. The petitioner shall refund all the amount that he has received from the fund, pay requisite fee, all along with interest, if any, for restoration of his sanad entitling him to practice, and on completion of all the formalities of such restoration of his sanad, he shall be restored to practice and his name shall be drawn back into the list of the advocates. Madam. ಇದೊಂದು ಬೇಡ ಮಿಕ್ಕಿದ 4 ಹೇಳಿ. Sorry. Big ಮುಗಿಸ್ಕೊಂಡು ಬರ್ತಾರೆ ಇಲ್ಲ 14%. ಹಾಂ ತಗೊಳ್ಳಿ ಪಾಸ್ವರ್ಡ್ ಕರೆದ್ಬಿಡಿ.
Passed over matters. Bill number 7.
Joint notice. The other matter I've adjourned it to some other day. ಜಗದೀಶ್ ಯಾವಾಗ್ಲೂ ಬರ್ತೀನಿ ಅಂದ್ರು. ದಿಸ್ NDPS 52 ಯಾವತ್ತು ಹಾಕ್ತೆ ಮೇಡಮ್ ಅದು? ದಿಸ್ ಅನದರ್ ಮ್ಯಾಟರ್. ಹಾ 25 ಯಾವತ್ತು ಹಾಕಿದೀನಿ ನೋಡಿ, ಸೀರಿಯಲ್ ನಂಬರ್ 25.
Second one.
List this matter on 2nd July. Yes.
Number 9.
Will direct conclusion of the trial. How many times do you five? What is? Now, in that I have observed everything. We'll dispose this with a direction for the concerned court to conclude the trial within 6 months. The petition, the petitioner is before this court seeking the following prayer. These very parties were before this court, you can dispose madam. 1031. For the reasons rendered in the said petition, the subject petition also deserves to be disposed only with a direction to the concerned court to conclude the proceedings within 6 months from the date of receipt of the copy of the order, as the proceedings are of the year 2018. 6 years have passed by. With the aforesaid observation, the present petition stands disposed, ordered accordingly.
Twenty-one.
You should secure it. I'll post it on 3rd. If that day it is not available, I'll defer framing of charges. The learned additional SPP submits that the statement of the victim under section 164 of the CRPC was recorded in Kerala, and the same is transmitted to the court of the magistrate here. The learned additional SPP would submit on the 3rd. If the matter is taken, the 164 statement would be placed before the court. List this matter on 3rd. Avat barlilla andre we'll see. Yes.
26.
No time. You file a synopsis of dates and events. Mic use ಮಾಡಿ ಬಳಗ್ರೆ. On ಮಾಡಿ.
She said that we have to execute the agreement between both of us. That I said I cannot.
What agreement?
Agreement for payment or extension of time.
How will they agree?
That is
Your
not,
affidavit of undertaking, I asked, not an agreement.
yes.
After the independence of the court, he sent a letter. I myself drafted a letter of complaint to schedule a meeting. This was not responded to for 24 hours, more than 24 hours. I reached out to council saying that sir, please ask the meeting to schedule. Meeting was scheduled. They initially said that we would seek for time. You give you 6 to 8 months time, not 9, only 6 months. They said 6 to 8 months time. Then I drafted a certificate saying that we will go to the court. It will be waiting 6 months. I said 8 months are not required, we instead to 6 months. They have been asking. That draft was shown. My friend appearing with the respondent responded by saying that party not inclined to sign anything. To make an undertaking to the court, if the court is inclined to give us 6 months time,
for 6 months.
No, see, that.
One minute, Balegre, Kelly. If you have to proceed under section 431, there is no order. There is no order of settlement. Settlement record ಮಾಡಿ ಯಾವ್ದಾರು court close ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ, ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ ತಾನೆ. So 431 is ruled out. ಅದನ್ನ ಮಾಡಿಸ್ಕೊಂಡು ನೀವು ಮಾಡೋ ಅಷ್ಟೊತ್ತಿಗೆ it will take time. ಅದ್ರ ಬದಲು 6 months you.
My submission, I never refused. I said what I said to her is, you file a affidavit, let the court decide. See, I cannot give any
Where is the
consent.
affidavit? No, that's all right. Now, where is the affidavit? No, that was,
I had one day before sent it across to the Respondent, and I had asked him if you want any correction, any modification, please send it. It was not responded to. On subsequent date of hearing, before this on the.
ಮಾಡಿ.
Parties are in agreement to extend the time, and I was taken by surprise here by learning counsel again for respondent that had not been agreed upon. When I confronted my.
no, don't be surprised about submissions or contra submissions. Now sit across and close it. Otherwise, time ಇಲ್ಲ ಅಂದ್ರೆ ನಿಮಗೂ 1 ವರ್ಷ 2 ವರ್ಷ ಆದ್ರೂ ಬರಲ್ಲ.
My submission to your, even now itself, I am making the submission, clearly making submission, let her file affidavit. If the court grants any time, we are bound by it. That is the same thing I told her also. No,
Not necessary.
Not necessary.
You file an affidavit of it. Are you fighting shy of filing an affidavit? Then fine. Yes. File then. You're here. When do you want it? Tuesday.
ಅಲ್ಲ, Tuesday.
List on Tuesday.
Wednesday,
ಅವ್ರು
Tuesday.
ಎಲ್ಲಿಂದನೋ ಬರೋದು.
ನನ್ನ ತುಂಬಾ ಮ್ಯಾಟ್ರ್ ಲಿಸ್ಟ್ ಆಗಿದೆ.
Monday,
Monday,
500.
Wednesday.
Wednesday, yes, Wednesday.
POCSO 28.
Yes.
My lord,
ಎಲ್ಲಿ ಇವರು additional.
My lord,
Jagdish had appeared. Where is he? He's not coming back? No, not that you are not needed here, but idರಲ್ಲಿ he had taken morning, I told him given some directions. You ask him, has he seen the sawmill matter ಅಂತ ಕೇಳಿ. Yes.
my lord,
Let him see the sawmill matter.
my lord, one
First,
submission is
password.
that, my lord.
ಪಾಸ್ವರ್.
My lord,
ಭೀಮನವರೇ,
ಅಲ್ಲ ಒಂದು
ನೀವು ಇರಿ ಸುಮ್ನೆ.
ಅಲ್ಲ ಒಂದು submission, para 6.
ನೀವು ಪಿ ಎಲ್ ಹಾಕ ಕಳಿಸ್ತೀನಿ ಅಷ್ಟೇ ಈಗ. ಎಲ್ಲ ಪಿ ಎಲ್ ಅಲ್ಲಿ ಆರ್ಗ್ಯೂ ಮಾಡೋದೆಲ್ಲ ಇಲ್ಲಿ ಮಾಡ್ತಾ ಇದ್ದೀರಾ.
No, that is not, my lord, as per his own government, my lord, he has stated that para 6, the owner is respondent number petition number 3, and he has obtained the agreement, and he has not produced that agreement. And he's, according to me, he's running the Tamil illegally.
Government will look into everything. Now I'll permit those families who are without food for 15 days.
No, as per the petitioner is.
ಅವ್ರು ಹೇಳ್ತಾರೆ. All right.
6 to 8% ಅವರೆಲ್ಲ ಬೇರೆ ಕಡೆ.
ಆರ್ ಇರ್ಲಿ.
ಅಲ್ಲ, daily wages ಬೇರೆ.
ಡೈಲಿ ವೇಜಸ್ ಹೋದ್ರೆ how will they survive?
ಬೇರೆ ಕಡೆ they have joined.
ಸ್ಟೇಟ್ ಗೆ ಏನಾಗ್ಬೇಕು, ಬೀಗ ಹಾಕೊಂಡ್ ಬಂದ್ಬಿಡ್ತಾರೆ.
My lord, and one more submission is that, while passing the order, my lord, let the complainant be present at the
For
opening
what?
of the sawmill, my lord, along with the.
ಟೇಪ್ ಕಟ್ ಮಾಡ್ತೀರಾ ನೀವು?
No, it is not so, my lord.
ಮತ್ತೆ
Let the video be videographed.
ಅದೆಲ್ಲ ಮಾಡ್ತೀವಿ, ಡೋಂಟ್ ವರಿ. ನೀವು ಟೇಪ್ ಕಟ್ ಮಾಡಕ್ಕೆ ಬಿಡಲ್ಲ.
My contention is that rosewood tree, all other trees are within the
I will
sawmill.
direct videograph, don't worry.
Okay.
Yes. And all that is seized will be aside, you will be permitted to run the sawmill. Madam, ask Jagdish to come. 4:30 ಬರಕ್ ಹೇಳಿ, ಪರವಾಗಿಲ್ಲ. No problem. We'll pass an order. Your affidavit, I will take your submission as an undertaking. You have say sought instructions? 4:15.
Watch me.
48.
ಯಾರು ಇಲ್ವಾ? Complied. Of his objections are said to be complied. List this matter on Monday in the fresh matters list.
55. Sorry, 52.
Settlement. Are they there online?
Due to technical issues, the respondent is not able to get into the VC.
ಆಯ್ತು ಕೊಡಿ.
SPA holder is present.
We'll close it. Madam, flag ಹಾಕಿದ್ದೀನಿ. ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಮಾತ್ರ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿ ಸೆಟಲ್ಡ್ ಬಿಫೋರ್ ದಿ ಮೀಡಿಯೇಷನ್ ಸೆಂಟರ್ ಅಂತ ಹಾಕಿ. Oh, they signed it there only. Yes, no problem. ಇದು pen drive ಇಸ್ಕೊಂಡು. Yes, give it in a pen drive and close it. Yes. Madam, 498A.
Party signature.
ಇದಕ್ಕೆ ಆ ಪ್ಯಾರಾಗ್ರಾಫ್ಸ್ ಒಂದು ಇದಾಕಿದ್ದೀನಿ, ಫ್ಲಾಗ್ ಹಾಕಿದ್ದೀನಿ, ಅದಕ್ಕೆ ಹಾಕ್ಬಿಟ್ಟು ಪೆನ್ ಡ್ರೈವ್ ಅಲ್ಲಿ ಏನಿರುತ್ತೆ ಅದನ್ನ ಹಾಕ್ಬಿಡಿ ಅಷ್ಟೇ.
55.
Settlement. A week's time, next week ಹಾಕಿ 5th.
Here for respondent.
ಎಲ್ಲಿ ಮೇಡಮ್ ಅವರು?
My lord, they may not come because the writ appeal has been dismissed.
I know writ appeal is
And
dismissed.
in the last hearing date, both were heard and today it was adjourned for the purpose of filing the supporting document. for
That is
the
what,
IAM.
where is the supporting document?
I have filed it, my lord. It's on the record. I have filed encumbrance certificate, my lord. Standing in the name of P. Shreyas.
PS. ಈಗೇನ್ ಕರೆಕ್ಷನ್ ಆಗ್ಬೇಕಾಗಿರೋದು?
In para 12, my lord, it has been mentioned that all the entries are changed in the name of the legal representatives of Shri K.V. Nanjappa.
Ah.
That is respondent number 2A to 2F.
So para 12 ಅಲ್ಲಿ it should be
It should be, the entries are made in the name of one P. Shreyas, eldest grandson of Shri K.V. Nanjappa.
the learned counsel for the petitioner has moved. ಅವಾಗ್ಲೇ ಯಾಕೆ ಹೇಳಿಲ್ಲ?
Respondent, my lord.
learned counsel for the ಅಲ್ಲ ಅವಾಗ್ಲೇ ಯಾಕೆ ಹೇಳಿಲ್ಲ?
I missed out, my lord. Apologies, my lord.
The learned counsel for the respondent in
R2A, my lord.
R2A has moved this matter seeking correction of the order. It is not objected to by the learned counsel for the petitioner. The correction is that the name of the legal para 12 madam. The corrected para would read as follows. The learned counsel appearing for respondent 2A submits that all the entries are changed in the name of one Shreyas,
P. Shreyas, eldest grandson
of Shri K.V. Nanjappa on implementation of the order passed by the assistant commissioner. This submission is placed on record. This paragraph shall be transposed to paragraph 12 of the order. And a certified copy be issued to the to the parties. Yes. ಯಾವ್ದು ಮೇಡಮ್? ಮಾಡಿ ಅಷ್ಟೇ 55 ಹೇಳಿ ಮೇಡಮ್.
Password 52.
ಅದು ಮೇಡಮ್ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿದ್ದು 55 ಅಲ್ಲಿ. ಇದು ಏನ್ ಸೆಟಲ್ಮೆಂಟ್?
ಮ್ಯಾರೇಜ್ ಆಗಿದ್ದಾರೆ ಸರ್.
ಮ್ಯಾರೇಜ್ ಆಗಿದಾರ?
ಮ್ಯಾರೇಜ್ ಆಗಿದ್ದಾರೆ.
498 ಬರೋದ್ ಮ್ಯಾರೇಜ್ ಆದ್ಮೇಲೆ
ಅಲ್ಲ 498 ಅಲ್ಲ ಸರ್.
ಮತ್ತೆ ಪೋಕ್ಸೋನ ಯಾವ್ದು 230 ತಗೊಂತೀನಿ ಅನ್ನಲ್ಲ ಅದ?
ಅದೇ ಸರ್.
ಇಬ್ರು ಮಕ್ಕಳಿದ್ದಾರೆ.
ಹೌದು.
ಮಾಡ್ಬೋದಾ? I know, that's good. ಎಲ್ಲಿ 2 months kid DNA ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಫರ್ನಿಶ್ ಮಾಡಿ.
DNA
Furnish ಮಾಡಿ.
registration.
ಫರ್ನಿಶ್.
What was the age of the victim when
21 years at the
ಅಲ್ಲ,
time
ಈಗ
of incident.
incident ಆದಾಗ 17
years.
What does he do? ಮತ್ತೆ ಬಿಟ್ಟು ಹೋಗಂಗಿಲ್ಲ. POCSO will revive. Yes, ಆ ಕಂಡೀಷನ್ ಅಲ್ಲಿ ಮಾಡಿ ಸೈನ್ ತಗೊಂಡ್ಬಿಡಿ ಮೇಡಮ್, ಅದು ಇಟ್ಟಿರಿ ನಾನು ಮಾಡ್ತೀನಿ ಸೆಟಲ್ಮೆಂಟ್ ನಾನು ಮಾಡ್ತೀನಿ. ಎಸ್. ಇಬ್ರು ಮಕ್ಕಳದು DNA ಇದೆಯಾ? ಬೋತ್ ದಿ ಚಿಲ್ಡ್ರನ್ DNA ಇದೆಯಾ?
It's at 2 months back.
2 months back. Right. Yes.
75.
ಅಯ್ಯ, ಮೇಡಮ್ ಫೈಲ್ ಸಿಂಬಲ್ ಇದೆ ಅದನ್ನು ತರಿಸ್ಕೊಂಡ್ಬಿಡಿ, ಸೈನ್ ಮಾಡಲಿ, ಪೇಷಂಟ್ ಸೈನ್ ಮಾಡಲಿ, ಆಮೇಲೆ ವಾಪಸ್ ಕಳಿಸಿ. ಇಂಟ್ರೆಸ್ಟ್
My lords, it is kept in a SB account, not in an FD account. Whatever applicable interest for the SB account, they will give, my lord.
ಅಷ್ಟು. Be satisfied with that.
They've still not approached the bank with the documents.
ಕ್ಲಾರಿಟಿ ತಗೊಂಡ್ ಬರ್ತಾರೆ, ಈ ಕ್ಲಾರಿಟಿ ಕೊಡ್ತೀವಿ ಬರ್ತಾರೆ. ನೀವು ಆಕ್ಷನ್ ಪರ್ಚೇಸರಾ?
My lords. My lords,
ಹಾ. ಅಲ್ಲ, ಬ್ಯಾಂಕಲ್ಲಿ ಯಾವ ದುಡ್ಡು ಕೊಟ್ರಿ ನೀವು? ಓ, ಮನಿ ಇಸ್ ಇನ್ ದ ಬ್ಯಾಂಕ್, ಇಸ್ ಇಟ್? ಹಾ. ಇವ್ರ ಹತ್ರ ಏನು?
excess amount, my lords.
ಓ,
Now not the excess amount was with the bank. Now at least the another people just say to take a petition.
Please,
after that.
my lords,
Other
it is
excess amount
kept in
bank
SB account. Whatever applicable interest for SB account, we are ready to give, my lord.
patients, medical expenses.
applicable bank interest, I will say,
My
on
lord.
deposits.
It is kept in an SB account. but
ಇದು ಇಂಟ್ರೆಸ್ಟ್ ಹೇಳಿದ್ನ ಅವತ್ತು ನಾನು.
It's not in the order.
It obviously so. The learned counsel has moved the matter seeking a direction on the score that at the time when the matter was disposed on 21st December 2023, out of inadvertence, the mention about the interest on the amount being returned to the petitioners was omitted. The omission has led to the filing of the application. It is ostensible that the amount was lying with the bank which belonged to the petitioners, as it was an excess amount after the sale proceeds being appropriated by the bank towards the loan. If the excess amount belonged to the petitioners, it was incumbent upon the bank, or is incumbent upon the bank, to grant interest at the bank rates at which they would charge for any deposit that is in the bank. Therefore, the amount be returned to the petitioners, the borrowers, at the along with interest at bank rates obtaining from time to time, as the bank would charge from the customers. Yes. Ordered accordingly.
86.
ಯಾಕೆ ಪಾಸ್ ಓವರ್ ಸೆಟಲ್ಮೆಂಟಾ? ಏನ್ 498? ಹಾ. ಸರಿ, ಈಗ ಏನಾಗ್ಬೇಕು ಹೇಳಿ? ಈಗ ಮೈಕ್ ಹಾಕೊಂಡು ಆನ್ ಮಾಡಿ ಸರ್.
Directed to file a contested petition. In view of this, I file contested petition, my lord.
ಕಂಟೆಸ್ಟೆಡ್ ಪಿಟಿಷನ್.
Yes, my lord. Earlier, moved for compromise, my lord. Annexure.
306.
58, my lord. Page number 58, my lord.
Oh, 498, 306.
306, yes, my lord. Since 2010, since 2014, my lord, till this matter is pending, my lord. See, two minor sons, and he is taking care of by the father, my lord.
Now, who is the complainant?
Complainant.
I appear for the
It's
respondent.
party ಅಲ್ಲಪ್ಪ ಕೇಳಿ.
Appear for the respondent.
No problem to quash. Who is taking care of the children?
Last 10 years, my lord, his husband is take care of the.
Husband is taking
You are
care.
married again?
No, no, man, no, man.
Not married?
Complainant is a senior citizen. He was a heart patient.
No, he need not be present. I am answering it on merits. But is the husband taking care of the children?
Yes, yes, my lord.
He is taking.
How old are the children?
One children. Sixteen and 13 years, my lord. After the incident, my lord, he is taking care of minor sons, my lord. He is not married. See, since 10 years, my lord,
ಅದೆಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಯ್ತು, ಮೆರಿಟ್ಸ್ ಮೇಲೆ.
my lord, no death note, my lord, in this matter.
So,
See, earlier, my lord, at the time of registering of complaint, my lord, 302 has been filed, my lord, FIR.
302 ಇಲ್ವಲ್ಲ ಈಗ 306.
306, my lord.
ಹ್ಮ್.
Even see in the earlier petition also, my lord, complainant filed affidavit also. I closed, I am also, I'm not interested, my
Complainant ಆಯ್ತಪ್ಪ. Now the
Yes.
wife is no more.
Yes.
You have abetted the suicide of the wife is the allegation.
Yes, my lord.
Then what? Merits ಮೇಲೆ ಹೇಳ್ಬೇಕೇನಾದ್ರು.
Yes, my lord, my lordship has been,
ಓದ್ಕೊಂಬನ್ನಿ,
yes, my
ಮಂಗಳವಾರ
lord.
ತಗೋತೀನಿ.
I have judgments, my lord, this
ಕೊಡಿ, ಎಲ್ಲ ಕೊಡಿ. I will take it on Tuesday.
Tuesday.
List
Yes.
on Tuesday in the fresh matters list. Intermodal ಇದೆಯಾ?
No interim order, my lord.
Tuesday in the fresh matters list.
God bless.
Yes.
ಕೊಟ್ಬಿಡಿ, please start ಮಾಡ್ತೀನಿ.
ಹಾ.
ಬೇರೆ ಇನ್ನೂ ಜಾಸ್ತಿ ಇದೆ.
3:30 ಯಾವ್ದಾರು ಇದೆಯಾ? ಕರ್ಕೊಡಿ. ಕರೆದ್ರಿ ಹಿಂಗೆ ಕರೀರಿ. ಇಲ್ಲ ಬಿ ಗ್ರೂಪ್ ಮುಗಿಸ್ಕೊಂಡು ಕರೀರಿ.
List continued, B group matters 115.
For the respondent in this matter. Look, Your Lordship's judgment last Friday in criminal petition 2998 of 2023, my lord. That's squarely applicable here. In this matter, my lord, we executed a compromise petition which was filed before the trial court, and after which, my lord, they committed a default.
ಹಾ, yes. Roaming
Yeah.
free now.
Yes, my lord. Only as they to protract trial there.
Then
The
we'll
evidence-
dismiss it, let him come.
Sure, he was here all this while.
List the matter on Tuesday in the fresh matters list. We close it. Yes.
116.
Covered by a number of decisions where Mr. Prasanna has appeared, a case, my lords, where the SP source reports on the same day. Oh, I'm sorry, I'm sorry, my lords. This is a case, no
ತುಂಬಾ
demand,
case ಆಗ್ಬಿಟ್ಟಿದೆ.
ಅದು ಇದು no demand, no acceptance, no work pending, stay order is there.
Stay order is there.
ಹೌದು.
ಇರ್ಲಿ ಬಿಡಿ. ಫಸ್ಟ್ ಎಂಟ್ರಿ ಮಾಡಿ ಇಲ್ಲದೆ ಇರೋ ಖಾಲಿ ಮಾಡೋಣ. 23.
ಇದರಲ್ಲಿ all the ingredients, my lord, demand ಇಲ್ಲ, acceptance ಇಲ್ಲ.
ಪ್ರಸನ್ನ ಅಂದ್ರೆ ಮತ್ತೆ ಪ್ರಸನ್ನ ಕುಮಾರ್.
ಅದಿನ್ ಇನ್ನೊಂದು 21, my lords, 121 ಅಲ್ಲಿ.
Yes. List on 24th. Interim order subsisting shall continue till the next date of hearing.
117.
My lords. The grievance, my lords. The petitioner herein is the original owner of the tipper lorry, my lords.
ಲಾರಿ ರಿಲೀಸ್ ಆಗ್ಬೇಕಾ?
Lorry release ಆಗಿದೆ ಸ್ವಾಮಿ.
ಮತ್ತೇನ್ ಬೇಕೀಗ?
Stranger person is applicant in this case.
ಇಂಟರ್ ಮಾಡ್ರಿ ಇಲ್ವಾ?
Interim order ಇಲ್ಲ.
ಇಲ್ಲ.
ಇಲ್ಲ ಸ್ವಾಮಿ.
List the matter on 24th in the fresh matters. ಅಲ್ಲ ಬೇಡ. 24th. There shall be an interim order of stay of further proceedings. Quay the petitioner till the next date of hearing.
Grateful, man.
Yes, next.
118.
The petitioner, my lord. My lord, in this case, I appear for the company. The complaint was filed by respondent 2, who was my manager, my lord. And a B report was filed and subsequently notices were issued to respondent 2 16 times. He has not appeared, my lord. I may be permitted to contest the matter.
ಇಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ. ಅವ್ರು ಎಲ್ಲಿದ್ದಾರೆ? ಹೌದಾ? ಸರಿ. ಇಲ್ಲ ಅಂದ್ರೆ ಅರ್ಜೆಂಟ್ ಮಾಡಿ ಅಷ್ಟೇ. ಮೇಡಮ್ ಇಂಟ್ರಿಮ್ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ ಅಂತ. ಇಂಟ್ರಿಮ್ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಇಲ್ಲ ಅಂದ್ರೆ ಅದು ಮಾಡಬೇಡಿ, ಅರ್ಜೆಂಟ್ ಅಷ್ಟೇ. ಎಸ್. Yes, sir. Sorry.
Yes, ma'am. My lord, the complaint was filed by the respondent 2, who was my manager, ma'am.
Yes.
And a B report was filed by the respondent police.
Hmm.
The trial court issued multiple notices to the respondent 2, and he has not appeared before the trial court.
Yes.
I may be permitted to contest the matter before the trial court to file my protest petition.
Who are you?
I am the company, ma'am.
The complainant has not registered a
Complainant was
protest?
my man, complainant respond.
No, was the complaint registered on behalf of the company through
Yes, my
that
lord.
man?
Yes, my lord. Page number 36, my lord.
State is a party, let him. Madam, have you seen this? ಅಲ್ಲ, see, on behalf of the company, the crime is registered. B report is filed by you, but the complainant has vanished later. Now the company wants to file a protest petition and contest the matter. That is rejected, is it?
Yes. No notice was issued to, I was not aware at all, my lord, when the case was closed.
The copy is there, madam. Just look into it. We'll take on Wednesday in the fresh matters list. Yes.
Much obliged.
119 adjourned, 120.
Let's seek for a big accommodation.
Only issue involved in this, my lord. A predicate offense is being stayed by this honorable court in one matter, my lord, where page number 58 of annexure, my lord, C. And consequently, the further proceedings of enforcement directorate is.
Predicate offense number ಹೇಳಿ ಅದೇನಾ ಇದು?
Please, my lord.
ಟ್ಯಾಗ್ ಆಗಿರೋದು ಅದೇನಾ?
No, my lord,
Par-
it's wrongly tagged along
Page,
with.
page number 58. my
ಯಾವ್ದು
lord.
FC ಟ್ಯಾಗ್ ಆಗ್ಬಿಟ್ಟಿದೆ GMS.
It was supposed to be tagged with criminal petition 8514 of 23, my lords. It is wrongly tagged along with.
ಟ್ಯಾಗ್ ದಿಸ್ ನೀವೇ ಬರ್ಕೊಟ್ಟಿರೋದಿಲ್ವಾ?
Now ಕೇಳಿ ಅದು 7117 ನಾವು ಬರ್ಕೊಟ್ಟು.
ಹೌದು ಅವರೇ ಬರ್ಕೊಟ್ಟಿದ್ದು.
The tag this petition along with the correct ಆಗಿ ಹೇಳಿ.
Some 7172 of 2023. my lord.
24 ಆಗ್ಬಿಟ್ಟಿದೆ.
24 ಆಗಿದೆ.
Tag this petition along with 7172 of 2023 and dealing writ petition 7172 of 2024 and post the matter before the bench having roster in if interim order, if any, in the said case shall continue till the next date of hearing. ಅದ್ರಲ್ಲಿ interim order ಇದ್ರೆ
Other- In that case, interim order is there.
ಅದ್ರಲ್ಲಿ ಇಲ್ದೇ ಇರೋ ಕೇಸ್ ಹೇಳ್ಬೇಡಿ, ಇರೋದನ್ನ ಹೇಳಿ.
No, in
Yes,
present case, that is.
Next. Yes, Mannan, wire tapping.
While trapping
Yeah.
quashed, my lords. This is
I
disproportionate,
know,
they said.
yes.
My lords, SP, he is the author of the source report, FIR and the order on the same day. One of those rare cases we find, my lords, where CBI has not done a PE at all.
Generally they do.
They do. In this case, probably it's because of that wiretapping, my lords. That is the incident that led to this. That's the starting point
Yes.
and covered by, I think, number of.
What is your,
My lord,
Objections?
I'm relying on the matters where
Kodi,
Prasanna has
ಎಲ್ಲ ಕೊಡಿ.
appeared on this side. There are about 6.
that's better to
That's it.
show. ಅದಕ್ಕೆ he has not come, we sent him
Same point, my lords, all the
demand and acceptance. ಇದರಲ್ಲಿ ಎಷ್ಟಿದೆ?
full set ಇದೆ.
50,000.
Alla, disproportionate now they're showing more. My income itself is not considered, partial income considered, my wife's income not considered, wife asset is taken, and they come up with a charge sheet. But more importantly, my lord, 17 order itself is bad. No application of mind, it's given to an inspector, no reasoning given to give it to an inspector, and all done on the same day. SP does all the 3 acts on the same day. Source report, FIR, as well as order under 17.
Under the DSP, inspector is empowered, so that is the reason.
Not,
You produce whatever you want.
Yes.
When do you file your objections?
That will file it in week or so.
And don't proceed till then. Interim ಇದೆಯಾ?
illa. It's come for the
Heard the
consideration.
learned senior counsel Sandesh Chowta appearing for the petitioner. The learned senior counsel would submit that the issue in the list stands covered by plethora of judgments rendered by this court and the coordinate benches of this court. The absence of demand acceptance.
Alla, idu demand act,
Que-
disproportionate, sir.
The non-application of
inquiry.
mind on the part of the authority permitting registration of the crime for offences punishable under section 13(1),
And 13(2).
13(1) and E and 13(2) of the Prevention of Corruption Act. The learned counsel for the respondent Rahul Krishna Reddy seeks 10 days time?
Yes.
10 days time to file statement of objections. Objections, if any, by the next date of hearing. List the matter on 24th. Till such time, further proceedings, the petitioner shall remain stayed.
Obliged.
Voting settlement, 122 adjourned, 123.
Petitioners are before the court.
Offense,
498.
thank you.
Participant.
498. ಎಲ್ಲಿ ಸೆಟಲ್ಮೆಂಟ್ ಆಗಿರೋದು?
Mediation alike.
Before the family.
Page
Page number 158.
158. ಕನ್ನಡದಲ್ಲಿದೆ?
Page number 160, my lord. John Memo filed by the board petitioner and respondent.
ಮೇಡಮ್ 160 to 160 1 ಫುಲ್ ಬೇಡ 160 ಅಲ್ಲಿ ಕ್ಲಾಸ್ 2 160 You are going to file petition for compromise under BNSS. ಅದಿನ್ನು July 1st ಬರೋದು. Page 161. You have drafted this.
Senior.
BNSS. Yes, ಅದು on page 160 to 161, one paragraph. Sign. Next. Yes. Madam, further hearing timing ಇರುತ್ತೆ ತಗೊಳ್ಳಿ. Further hearing ನೋಟ್ ಟೈಮಿಂಗ್ ಯಾವ್ದಿದೆ ಅಂತ ತಗೊಳ್ಳಿ. ಟೈಮ್ ಕೊಟ್ಟಿರೋದು. ಸೆಟಲ್ಮೆಂಟ್ ಆದ್ಮೇಲೆ. ಅದು ಸೆಟಲ್ಮೆಂಟಾ?
The 498, 306.
ಅದು ಆಗಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್. 306, 498, even I told Manjunath Gowda also.
Merit and merits also, my lord, after leading 22 years of married life. Unfortunately, my lord, she died of hanging herself. She was suffering from depression. My lord, 2 kids are college going, 2 kids are there. And third, my lord, the 3/8/2022 incident happened. My lord, I would file a complaint, first person would file a complaint, report the matter. But 20 days, keep quiet. Well, after 20
You are married again?
No, my lord, no intention to marry.
No intention?
No intention. 22 years, I've got 22 years old kids. My lord. And now, of late, my lord, brother-in-law who was staying away from Bangalore would file a
Who is
complaint.
the petitioner here?
Petitioner, husband and father-in-law.
appearing on behalf of respondent number 2, filing Gopala. ನಮ್ಗೇನ್ ತೊಂದ್ರೆ ಆಗಿಲ್ಲ ಅವರಿಂದ.
ಏನ್ ತೊಂದರೆ ಆಗಿಲ್ವಾ?
Conception ಇಂದ
ಆಯ್ತು,
complaint
merits ಮೇಲೆ ಬರೀ.
At the earliest, my lord,
Wednesday, no settlement.
not settlement, my lord, at the earliest, my lord, when they were having an opportunity to say before the investigation officer during inquest, that was the
I
best
told you
time.
on the last occasion, no settlement, don't get the parties.
No settlement, my lord. The
Why to
merits,
get the parties then?
not mainly on the settlement. my lord,
I'll take it on Wednesday.
Please.
Wednesday in the fresh matters list. ಅದು ಮಂಜುನಾಥ್ ಗೌಡ್ದು ಯಾವತ್ತು ಹಾಕ್ತೆ ಮೇಡಮ್? ಅವತ್ತೇ ಹಾಕಿದ್ದೀನಿ. ಇನ್ನೊಂದು ಇದೆ ಸರ್, 498, 306. ಆಯ್ತು,
Great.
330 ಯಾವ್ದು? ಮೊಹಮ್ಮದ್ ತಾಹಿರ್ದು. ಸೈನ್ ಮಾಡಿದ್ದೀನಿ, ಮೆಮೊ ಸೈನ್ ಮಾಡಿದ್ದೀನಿ. ಎಸ್.
Further hearing?
P.
3:30 PM, 130.
I'm led by Mr. KG Raghavan Melats. He is before the Chief's Court. May I request a short passover? We are ready to proceed.
Intimidating before the Chief's Court.
No. That he is on this. May I just make one request, Melats? A statement was made on the last date that a complaint has been filed in Russia against the divorce which we are relying.
Russia?
Not Russia, Dubai.
Not in Russia.
A copy, if it is given to us, we'll be able to respond. No
Complaint
copy
was
is
filed in Dubai is what she said.
Dubai.
If a copy is given to us, we'll be able to respond. Otherwise,
Because it was not cancelled in Russia.
Please.
No, it wasn't. Her complaint that she's given
You
of
have a
the
copy of it?
harassment, I have that. And the very day that we finished our arguments, within 5 minutes, she gets a message from him stating, did you file a police complaint against me? In fact,
Which year?
here, the moment we finished immediately after that. Now, she has not proceeded with the registration, though the police have given her a docket number. Reason being, your lordship, over there, it is proven that he has committed forgery and gone without her over there. It's such a serious offense there that he would be behind bars. So she has not followed it up, but I have all the details of the complaint.
Just take a copy and we'll.
If I give that right away, your lordship, again, one more round of intimidation will start. So whenever they're ready to argue, I'll probably.
Argument time ಅಲ್ಲಿ ಕೊಡ್ತಾರೆ ಬಿಡಿ.
Won't be able to respond. It will keep on going on date to date.
That is not for response, for information.
Show this honorable court that she did file a
But they
complaint.
admit it's not right. I'll leave it.
Let the argument start.
Please. I'm great.
Passed over, your lordship.
Pass over. Yes. Now continue with the.
Lordship, there's another passed over also, your lordship,
Nimda.
89. That was that matter with respect to.
Huh?
430.
430 ಅಂತ ಹೇಳಿದ್ರು.
87.
He asked for 430. No.
430.
Senior counsel Hashmat
Please,
Pasha asked for 430.
Please, obliged.
That's 498A.
That is 306, Your Lordship.
306.
Please. But the handwriting, Your Lordship said it referred that.
Oh, that handwritten. thing.
Handwriting, yes.
We'll refer it to FS. Sir, we'll take it at 4:30. Asmat Pasha.
Yes, my lord, I will be physically present, my lord.
It's 4:30, sir.
Yes, your lordship. Oblige you.
Order hearing 125.
Why is Vikram sir waiting? What happened? You were not well, you're all right now?
Oddly enough, the party I represent. Raste ಮೇಲೆ ಓಡ್ತಾ ಇದ್ದೆ ಬಿದ್ದೆ. So fractured. But I
Take
honestly-
care. Why did you can sit and argue if you want.
No problem. In fact, for the same case, in fact, Mr. Raghavan was leading us. I was also asked.
All
to
right.
lead him.
I've
So I
passed
just
it
came, I
over.
didn't know it was passed over. I'll come back.
Not possible to stand and submit, you can sit.
No,
and
no
submit.
problem. I can stand.
Yes.
Wait.
125.
120?
Lord, in the last petition, that the complaint came to be filed by the complainant saying that I have demanded of illegal gratification for the purpose, illegal gratification of 1,50,000 rupees. No demand, no acceptance, and no recovery.
You said
Only-
recordings are there?
Yes, ma'am.
Yes.
Yes, ma'am. Transcript is part of the charge.
That's a charge sheet?
Yes, ma'am. Charge sheet, the
File
petitioner.
ಮಾಡಿದ್ದೀರಾ?
I have filed the charge sheet. Memo dated 13/7/2023 itself. And I filed a synopsis also. ma'am.
ಆಯ್ತು ನೋಡ್ಕೊಂಬರ್ದು. 5th ಗೆ I will dictate. ಸಿನಾಪ್ಸಿಸ್ ಇಬ್ರು ಹಾಕಿದ್ದೀರಾ?
We have filed.
ನೀವು ಹಾಕಿದ್ದೀರಾ? 5th further hearing ಅಂತ ಹಾಕಿ will dictate on that.
126 14.
ಅದು ಬೇರೆ ಕೋರ್ಟ್ಗೆ ಹೋಯ್ತಲ್ಲ. ಏನು? ಏನಾಗ್ಬೇಕು? Madam, 126 ಅಲ್ಲಿ, the petitioner appearing in person submits that the coordinate bench hyphen Honorable Shri Justice K. Natarajan had heard the matter on 20 occasions and therefore submits that the matter should be posted before the very same learned judge as he has heard the matter on the aforesaid number of occasions and had been treated as further hearing. Therefore, registry to post the matter before the same honorable judge after obtaining the orders of the Honorable Chief Justice. Yes.
127.
Appearing for petition this case, my lord. Short accommodation notes on Tuesday.
Why?
There is held up in another court hall.
ಯಾವ್ದಿದು?
This is
a
a
matter
138, my lords.
Affidavit 138.
evidence of the accused was filed. That was sought to be challenged. And in fact, this is covered by the judgment of the Honorable Supreme Court and also the dishonorable court. The accused is also entitled to file the affidavit evidence.
ಅಷ್ಟೇ ಬೇಕಾಗಿರೋದು ಕೊಡಿ.
Yeah, lordship. This is, Lord, your lordship may kindly turn
Indian
to
Bank Association, yes.
ink page number 11.
Monday or Tuesday in the fresh matters list.
Please.
Close it on Tuesday. Yes. List on Tuesday in the fresh matters list.
Please. Interim order.
Interim order ಇದೆಯಾ? Interim order subsisting shall continue to the next date. Okay.
Please.
28 urgent 129.
Madam, ಇದು ಸೋನಿಯಾ ಕೊಡಿ. ಕೊಟ್ಬಿಟ್ಟು ಇದಾದ್ಮೇಲೆ ಯಾವ್ದು ಈ ಲೈನ್ ಅಲ್ಲಿ ಯಾವ ಜಡ್ಮೆಂಟ್ ಇದೆ ಬರುತ್ತೆ.
For the respondents 23, my lord.
I've adjourned your matter.
My lord, this is another matter. At Bar Council matter. My lord,
But again it is same. Yes, yes.
my lord, the matter pleadings have already been completed. My lords may dispose of the first petition 9713 because the only
madam.
thing adjudication of which remains pending.
Serial number?
97, it's 129. And there is a connected matter at 129.1. My lord, in that notices are required to be issued because, and I have also filed a memo for dispensation of notice to respondent 2 to 30 because they are not as necessary parties to the list and they are not likely to be affected by it.
ನೋಟಿಸ್ ಯಾರಿಗೆ ತಾವು ಕೆವೆಟ್ಲಿದ್ದೀರಾ?
ಅದರಲ್ಲಿ ಇಲ್ಲ.
ಇದರಲ್ಲಿ ಇಲ್ವಾ? ಅಲ್ಲ ಮೊಹಮ್ಮದ್ ತಾಹಿರ್ ಅಂತ ಇದೆ.
129.1 ನಲ್ಲಿ
ಹಾ.
ಕೇವಿಟ್ ಏನಿರಲಿಲ್ಲ, ಆದ್ರೆ ಅವ್ರೇನೋ ಕಾಪಿ ಎಲ್ಲರಿಗೂ ಕೊಟ್ಟಿದಾರಂತೆ.
My lord, it was served pursuant.
All right, will
But it has not-
direct notices.
My lord, to responding number 1 only. Because there is a
One
memo
minute,
for
I'll see.
dispensation.
Madam, ಅದು ಕೊಡಿ, connected matter ಕೊಡಿ. There are so many respondents.
My lord, 2 to 30 are the respondents along with the plaintiffs, present petitioners.
So 2
before
to
the-
13 not required?
Not required, my lord. They will be supporting our case on. And they are not likely to be prejudiced by any adjudication in their absence.
1 minute, 1 minute.
My lord.
2 to 13.
2 to 30.
So up to Vijay Karnataka. 13th respondent is Vijay Karnataka.
My lord, last.
Correct?
Yes, ma'am.
Yes, 2 to 13 ಬೇಕಾಗಿಲ್ಲ.
My lord, it's WhatsApp, Facebook, India.
WhatsApp?
WhatsApp, Facebook, India is the 30th respondent.
30.
30, my lord.
Oh.
2 to 30. 30.
WhatsApp, Facebook, India. Till there, no, not necessary.
They are not necessary and in case.
Yes. Though notice only to one.
Only to one. He is the sole
You
plaintiff
will
before
take
the trial court.
notice.
My lord, in case they take notice, I have spare copies to serve.
True, but you used to file a memo. That notice is not required to all
I
the
have
others.
already filed it.
Already filed?
Already filed. Memo for dispensation to notice, dispensation notice to responding number 2 to 30.
Yes. The petitioner has filed an application seeking dispensation of issuance of notice upon respondents 2 to 30. In the light of the application, in the light of the application so and so, at the risk of the petitioners, the notice to 2 to 30 is dispensed with. One ಯಾರು ತಗೊಂತೀರಾ? Patil sir.
My learned friend will take notice. Of course,
Joseph.
Tahir's name is shown as KVATR, but wrongly shown. He is KVATR in serial number 129. Same KVAT is shown even for 129.1.
All right.
Anyway,
Learned Counsel Joseph Anthony.
Tahir
Krishna.
will take notice.
Mohammad Tahir only will take. Learned Counsel Mohammad Tahir accepts notice for the first respondent. Petitioner to serve set of papers upon the said counsel. So now what?
In this petition, my lord, they may file their response.
They will.
They may file their response. In this petition, I'll press for stay of the ex parte ad interim order, which is.
Since when? This is the one you are telling that you have challenged the order. What is the date of the order before the trial court?
As regards
it's
the
in
interim
July.
prayer, my lord, I pray for 2 weeks' time to file objections.
No, what was the date of the order before the trial court?
My lord, it's July, it's in July.
July when?
I need to seek instructions.
2022 or 21 or 23?
February.
9th of July? My lord, it's 9th of July.
9 July 23.
24.
24? Where is the order?
My lord.
Where is the impugned order?
Come. The next week of hearing before the trial court in this matter, 1006.
ಯಾವತ್ತು ಸರ್ ಆಗಿರೋದು?
My lord, it's 9th of July 2024.
24. What is this?
My lord, the date of the impugned order is.
Date of the impugned order I'm asking. What have you challenged in this case?
I got little confused. That
What have you challenged?
I have filed 9th of February 2023 order.
You have, I'm not telling when you filed the petition. What is under challenge?
It is the 9th of February 2023 order passed by the trial court in
Yes.
original suit instituted by respondent number 1.
2 orders you have challenged. 9/2/2023, 7/8/2023.
7/8/2023.
So we'll permit them to file objections.
My lord,
The order that has stood for 14 months will not be stayed ex parte.
my lord, that order is an also ex parte ad interim order.
No
and-
problem. You've challenged that on that ground. Should I also commit the same mistake?
My lord, I press for the stay,
Hmm.
specifically in one ground. My lord. It's an ad interim order, and under the statute, it cannot be continued for more than 30 days, my lord.
No problem. We'll see.
So that's my only section. However, if your lordships are
We'll
inclined to
hear
give them time,
Ad interim order stage ಹೋಗ್ಬಿಟ್ಟಿದೆ ಈಗ.
my lord.
We'll have to hear and pass now.
We will file objections to the effect that they made an application for change of presiding officer, which resulted in
But that's my right.
application being not heard.
But all those facts have been stated in the writ petition. They will be heard, argued before this court.
No problem.
My lord,
Let them file their objections.
my lord, if your lordships are inclined to give them time, and then
Don't tell
I-
inclined to all. We have to give them opportunity
my lord,
because the order is not passed yesterday.
my lord, we are not being substantially prejudiced.
It's okay.
That's why
but
I
see-
will not press for it
No,
today.
no, no. Don't, I'm not on those things. See, the order has stood the time from 9/2/23 or 7/8/23 till today.
Despite
Either,
all,
either it is 14 months or 8 months, whatever. Let them file their objections, we'll consider.
and that's very well. I'll not press any more for that.
Eh.
My lord, the other petition,
Ah,
my lord, that in that pleadings are complete.
yes.
And my lords, I may proceed to argue. I mean, make
As
a
regards
request.
9713 of
9713.
24, serial number 129. I request, my lord, my application, rather application by respondents 2 and 3
What
to
application?
strike down the
Pleadings.
certain pleadings.
No, no.
May kindly be taken up
We will
first.
not,
my lord.
we will not consider it piecemeal. If there is anything to be considered, whole hog we will consider and
That's-
close.
But with
So
the.
let her start. What, main petition, this is 48,
My
right?
lord, I'll explain.
Revisional,
Yes, my lord.
Huh.
My lord, the petitioners challenge before this court.
Why we are saying this is, my lord, of course, subject to what they are, not that I have any grievance against my learned friend appearing here. They want these pleadings to be read. That is what we are opposing. In case such a situation arises, we are making a request that this proceeding may be taken in camera. If necessary, we are filing an application also.
in camera.
Yes, madam. That is the only this thing. Let them start, let them argue the matter, but situation is of such a nature
No.
that it,
Yeah, all right. You are asking for a proceeding which is here to be in camera. Everything is already in camera here.
not the open to the public. That is
Live,
why-
live streaming, sir.
My lord,
No, we'll do it, yes. No, it's a lighter way, yes.
my lord, as far as the present matter is concerned, I wish to apprise this honorable court as well as the senior counsel appearing that I have taken all the precautions not to take names, my lord. I am filing a
Question of
memo.
taking
Last time
names.
itself, she
Not
said
the
she will.
question of
I am
taking
filing a
names, my lord,
memo.
I would only put it, my lord, the pleadings are of such a nature, I would just for the
All
this
right,
thing,
if it is of that nature, we'll take it in camera, no problem.
that's why I said, one of the
allow me to-
paragraph, your lordship may just go through para 17 of the pleadings. It is something which I would say requires to be in camera.
What, Nisha madam, what is this?
My lord, may I kindly be permitted to start the argument at least, so
Hmm.
that this honorable court may be apprised of the contents of the writ petition or whatever it is. And I assure this honorable court that since your lordship already cautioned me on the previous occasion not to take snip,
Hmm.
that's why I have prepared a memo for abbreviations that I will be referring certain individuals by those abbreviations only. I'll take every possible precaution not to allegedly defame anyone while arguing the matter. And my lord, since transparency in this matter is the essence of the hearing, my lord, I strongly oppose any such request for in-camera proceeding.
You filed an application.
Yes, my lord, we are filing an application.
How about
Good.
transparency, my lord?
My lord, is something I'm alleging it to be true. It should be heard, my lord.
Point out, one judgment, my lord, they are referring, judgment has been confirmed by the division bench, confirmed by the Supreme Court. There are all kinds of allegations.
It's I didn't want to say, no, Lord.
My lord, I may
it is not
kindly be
something
No, but.
So I have first right of
Elect
audience,
against
my lord,
judges
being
of this
petitioner
honorable
counsel.
court.
All right. No, what is page 24 as I see para 17, what is, why all this
Page 24 of the
of the petition?
9713.
What is this? 9713. Insofar as the bar council thing is concerned, I have already directed you to go to the revisional court.
My
Now
lord,
what
this-
remains is the application.
My lord. My lord, these all are facts, my lord. These all are facts and there was the allegations before the Bar Council of Karnataka against the respondent advocates.
This was already printed there.
No,
My lord,
it's not there.
In the complaint, this was already there.
everything is there, but nothing new has come before this court and it
Please
can't.
have a look at, my lord, the complaint itself.
Where is the complaint? No, if you have quoted what is verbatim in the, from the complaint, no problem. You have added something to it.
My
then
lords,
yes.
may allow me some time.
Yes,
I'll
definitely.
I'll proceed with the
All
argument.
right.
I'll convince your lordship that nothing scandalous or nothing frivolous has been stated. And my lord, first and foremost, I'll pass on the memo for abbreviations.
It's all right. Memo taken. Yes.
I'll pass it on. My lord, initially, complaint was filed before the Bar Council of Karnataka, alleging certain professional misconduct by the respondent advocates while conducting their matter before the trial court as well as before this honorable court. Pursuant to that complaint, we sought to produce certain documents and all to support our complaint. However, the Bar Council of Karnataka rejected to forward the complaint to the disciplinary committee under section 35(1) of the Act.
Yes.
And exceeding its jurisdiction, decided the complaint on merits after receiving a response from the respondents and without serving a copy of that response to us. That complaint was rejected. And that order of adjudication by the non-jurisdictional order was assailed before this honorable court. However, my lord, despite that being a non-jurisdictional order and in past in violation of principle of justice, I failed to convince your lordship to adjudicate the matter on merits. And
No, it was passed without hearing you.
it was passed without hearing me. It was beyond the competence of the authority, beyond the competence of the Bar Council, State Bar Council to pass that order on merits. The law provides that it should be referred to disciplinary committee for
Yes.
adjudication.
35, you file a complaint, then if the
It should-
complaint is to be entertained, it will go before the disciplinary committee.
Disciplinary committee.
If the committee feels that it is not even worthy of being sent to the disciplinary committee, it is closed.
But
Once it is closed, your remedy is under section 48 to file a revision before the Bar Council of
it's
India.
an alternative remedy, my lord.
Ah.
And in this case, my lord, all the, in my respectful submission, since it was a non-jurisdictional order, because they entertained the complaint on merits, they called for a response which was beyond their competence. And therefore, it was
Who called for response?
before referring to disciplinary committee, the Bar Council called for a response from the respondent.
Are they not empowered to under section 35?
My lord, to the best of my understanding, they are not empowered to call for a response. Rather, they can prima facie assess as to whether there is any case for professional misconduct, prima facie or not. If it is, then it has to be referred to disciplinary committee. A disciplinary committee will ask for a response, will allow us to peruse that response, respond to it. There used to be a detailed procedure then it has to be adjudicated upon. But neither their response was served on us, nor we were given any
Is it-
opportunity. I'm sorry.
You ask him to stand.
I'm sorry.
Hmm.
However, that order has, since your lordship on the very first date, declined to entertain it on merits and to adjudicate upon that order.
Hmm.
Therefore, I order
Anyway, I have
was-
not disposed the petition. You can tell.
but
Hmm.
since the order was already dictated in open court,
Yes, it is.
so therefore I will not press for it, my lord.
All right.
And subsequent to disposal of the petition, when your lordships had already passed order, this application seeking injunction from
Yes,
publication
it was filed there.
It was filed then and there, and your lordship were pleased to give me time to respond to it because I was unaware as to what was the contents. Pursuant to that, however, on that very day, my lord, this honorable court was told that there is a valid injunction order as regards the present content subsisting against the petitioner. And your lordship also observed that I am not doing anything new. Rather, I am extending this order further to this petition, if the contents are same. I bowed down to your lordship's observation because I was also not aware of that order, in essence. That order was passed by the trial court with regard to different content, my lord, which is a subject matter of challenge in the connected petition.
Correct.
And that covers a sexually explicit content allegedly involving respondent number 3 herein, who was plaintiff before the trial court. And it was obtained on the pretext that there is some obscene content in possession of private defendant associated with the petitioner, which may go public against respondent number 3 to cause disrepute to him and to disturb his matrimonial relationship also. And this was also pleading that some disclosure to his wife has also caused miscarriage to her. These all were the pleadings. So, my lord, we are not at all concerned.
That's
That's
suit matter, my lord. Your lordship have said, my lord, we'll have to file our objections. She is now arguing the suit matter or my lord?
My lord, because the order passed in 9713,
No,
the main
the
matter.
on the
is the
interlocutory
basis of-
application that I have passed an order restraining touches upon that is what is.
My lord, your lordship have categorically recorded that they are heavily relying on that order, and the mention of that order
Then
finds in your,
Nisha madam, we'll let them file objections. We will clear both.
not on
them.
that, not on that. That matter is altogether different. I'm just surprising this honorable court that what has actually happened and what fraud was played to get an order ex parte ad interim order from your lordship.
Eh?
My lord, on that very day, they were granted interim injunction by this court that there will not be any.
Oh,
publication.
that's a huge word. You can't use fraud or
My lord,
spleen.
I will
No.
be able to substantiate, my lord.
They have filed an application, made submission. They said interim order is there. I have
It's
granted.
there, my lord.
You are
but-
entitled to seek vacation of it, but
My
do
lord,
not say that they have played fraud on this court
My
to
lord,
take an
sub-
interim order. It's
whatever
not
submission I made, I'll substantiate. If this honorable court was misled into believing that there is a valid injunction already subsisting, passed by a competent court of law, then anybody will obviously, my lord, proceed on that premise only. And if your lordships observe that that order has no bearing, then it is clear-cut case of fraud, my lord. However,
I have to observe first. You can't be putting the
Yes, ma'am.
cart before the
my lord,
horse.
it's my submission, I will substantiate.
Fraud anta, when I say yes, I was, this is not what the order, then you can straight away say anything. Yes.
My lord, that I have
No,
advanced as a
alleging,
submission.
because alleging someone has played fraud in, they have made submission and I have looked into the order of the trial court and granted an order.
My lord, if it is found that I'm making a wrong submission, it may be
That's all.
rejected.
See, nobody.
It's my submission,
See,
my lord,
that's all.
that this court was misled. That's the
That's
crux
all.
of it.
Yes, all right.
I will not use word fraud.
Yes.
This court was misled. And
Not see, these overtones are not needed is what. Come on, merits, we will answer. Yes,
I apologize.
yes.
I'll keep that in mind.
Yeah, no problem.
My lord, since the IA was filed on that day, I have filed my objections on the subsequent date. One particular fact which I wish to apprise this court, that the another application seeking striking of pleadings from the writ petition was supposed and award to be filed on that very day of first day of hearing, but it was not filed on that day. It was filed a month later. What was the intent of filing that subsequently? That I'm not aware, and obviously that could be a reason for causing delay of the disclosure. My lord, that was served on me a month later when I was on the dais. So that time may be given to, but however I responded to it in 2 days. So that actually not has caused any harm to me.
All right, yes. Still.
So, my lord, I'll now oppose that interim application, the injunction. There are various important issues which arise for this consideration of this honorable court as to the prayer for injunction. Their case is that the contents of the writ petition and the annexures are defamatory in nature.
Yes.
My lord, the law with regard to injunction as regard defamatory content clearly says that first and foremost, if something is being alleged to be defamatory and the other side who is being alleged of defamation is advancing a defense of truth, that he will prove the allegations level, then presumption will be in favor of free speech. Until unless they prove that whatever I say is false, they don't have a case, they don't have a cause of action to agitate before this court. Secondly, my lord, until unless they displace this presumption, they are not supposed to be granted any relief, even ex parte ad interim relief. And there was no satisfaction, with all due respect to your lordship. In the initial order of 24th of April, there was no analysis with regard to the prima facie case, balance of convenience or irreparable harm. There was no analysis as to the judgment reliance on which was placed by them, how it applies to the facts of the case. And this was clearly observed by the Supreme Court in the recent authority in Bloomberg case. And it remains a settled law since the Chancery Division judgment in the Bernard versus Perriman. And it has time and again been followed. So, my lord, that order.
Not to follow a judgment blindly.
Sorry, my lord.
Not to follow a precedent blindly. Yes.
Yes, my lord. There is no analysis, my lord. There is submission and then judgment and then
They're
categorical.
not Euclid's theorem. Yes.
So, my lord, first, that this injunction which is being sought, so they need to prove their case, that whatever is the allegation, they need to substantiate it, and this will involve a long trial process, because there will be evidence, there will be examination of witnesses to prove the truth, which is essentially a job of the trial court, my lord. And I raise my preliminary objection to the maintainability of the writ petition on the ground of jurisdiction, that it is essentially a dispute of a civil nature, and this honorable court does not have the jurisdiction to entertain such a suit, such a plea, which is a subject, which could be a subject matter of a litigation before the trial court under section 9 of CPC. Second objection, my lord, subsequent to the grant of ad interim order in the connected matter before the trial court, they filed another affidavit bringing on record the very same content which is contained in the present writ petition, my lord. Now that content is also subject matter of adjudication before the trial court. It will also be considered by the trial court. So section 10 CPC also operates to their prejudice. These are two preliminary submissions, preliminary objections, my lord, to the very maintainability of the application. That first, this honorable court also does not have the original jurisdiction to treat it as an independent suit. And under section 151 CPC, my lord, this cannot be a substitute. This proceeding cannot be a substitute to a fresh suit. In case they are aggrieved by any such defamation, alleged defamation, then they should institute a suit categorically stating that these are the contents which are defamatory, and they should obtain an injunction from.
You're answering the application seeking striking off the pleadings.
Seeking injunction against the publication as well as the striking of.
Let them file their objections to that
My lord, they
petition.
have already filed it on 30.
Where?
My lord, it was their application. I have filed my objections. They filed
For the court, trial court.
before your lordship.
No, this second petition where you have challenged.
My lord, that adjudication is altogether different.
All
That
right.
adjudication is different. That
All
that
right.
has nothing to do with it. So, my lord, on these two counts, I would like to take this honorable court to the authorities on the issue of jurisdiction.
Yes, give it.
My lords, I may kindly be permitted to pass on this list of authorities. Sir.
Who are the petitioners?
Petitioners are us, my lord.
No. Who are they?
They are private parties who engage them for their matter. For
Oh, they
conducting.
are the ones who had given wakalat to these respondents.
My lord,
They are the clients.
they are the clients.
Oh,
They are the clients.
not strangers.
No, certainly
Oh,
not.
fine.
That's not maintained.
All right. No, my clarification. Yes.
Yes, my lord.
Yes.
My lord, authority number 13 at page 261.
Two 261.
261.
Yes, madam.
My lord, it reads after the quotation, the power under subsection 4 of section 29A of the Arbitration Act vests in the court as defined in section 21E of the Arbitration Act. It is the principal civil court of original jurisdiction in a district which includes a high court, provided the high court has ordinary original civil jurisdiction. So my submission on this authority is limited to the extent that until and unless a high court has original civil jurisdiction, such a plea cannot be entertained. The other authority, my lord, on the issue of jurisdiction is para 28 at page 249. The lordship will find it. At 255, madam.
259.
255.
5. Yes.
Section 151 of the CPC can only be applicable if there is no alternative remedy available in accordance with the existing provisions of law. Such inherent power cannot override statutory prohibitions or create remedies which are not contemplated under the code. Section 151 cannot be invoked as an alternative to filing fresh suits, appeals, revisions, or reviews. A party cannot find solace in section 151 to allege and rectify historic wrongs, so and so. My lord, these are the two authorities which I am relying upon. And, my lord, to this, they may respond, because after that, the necessity of responding to all other submissions or to advancing other submissions may not arise. So they may respond.
Let
and
them cross the threshold bar.
My lord, that's,
What you're trying to
this is
say.
one, not just this one, my lord.
Hmm.
Even subsequently, once these objections are struck down by this court, then also they should open up their case and they should establish that how they are entitled to such a relief before this court by establishing their prima facie case, by negating and displacing my presumption of truth.
Okay.
My lord, they may respond.
Yes, are you responding today? Yes, sir.
Our response would be, my lord, of course, not only with reference to this, it is this response I requested that our IA for striking down the pleading
Be first
may kindly be
considered.
taken up first. That
File your
was the
objections to
reason.
that IA? Readings are complete on that also.
Then,
I'll hear on that also.
please, therefore, that was one of the reason I said,
Then I'll take it on Tuesday.
ಆಗ್ಬೋದು.
You are there on
In the
Tuesday or
meanwhile-
Wednesday, when I have given the date to you.
Lord, Wednesday, lordships again. Tuesday, I'm available.
You are here.
Yes, ma'am.
Yes.
I have other matters also.
Oh, Tuesday, yes.
And of
My
course, my lord, not that I have anything, this thing. The submission that I am taking preliminary objection, let it be decided thereafter next. Of course, it's fine as an argument, but to submit it to the court that you decide this, you decide that, all these things are not something which I would say to be appreciated, particularly in a matter of this nature.
My lord, if, though I was not willing to say this, my lord, this was the petition challenging the conduct of two advocates, my lord.
It's
But-
all right.
My lord, kindly allow me to make this submission.
Yes.
When the very first day when I appeared and I apprised this honorable court that I am an all-station advocate, learned senior advocate appearing for the respondent said, the petitioner could not get a local counsel, my lord. This remark was made, I did not respond to it. This petition, my lord, involves the professional conduct. And, my lord, in the previous round of litigation, wherein the conduct is in question, learned senior advocate, Mr. B.S. Sorry,
No.
I'm so
The
sorry.
kind
I'm
of
so
thing, my
sorry.
lord, that I will have to.
I'm
No
sorry.
names.
Mr.
This is, my lord, what has
J.S.
been
Patil,
happening.
Mr. J.S. Patil.
The whole game plan, my lord, is that.
I'm really
That is
sorry.
why,
I'm
my lord,
really
an order was
apologetic, my lord.
passed.
I told you, no names.
It's a
not
slip
this.
of tongue. I sincerely apologize.
All this, my lord, is in a very, very, my lord, subtle way to, my lord, inject all
My lord,
this.
Mr.
Very, very,
Patil,
my lord, we understand this,
No,
my
no,
lord,
by
methodology.
slip of tongue it came, yes.
my lord, Mr. Patil
Huh.
appeared for the petitioners themselves, where in the proceedings in which the conduct of their briefing counsel
All right.
was
You-
in question, my lord. And Mr. Hulla, Mr. Senior Advocate Mr. Hulla appeared for one of the contesting respondents, opponents of the petitioner.
Now, what has
My
that
lord-
got to do with all
My lord,
this?
the very conduct is in question in those proceedings also.
Sorry.
And to the best of
This,
my
my lord,
understanding, my
I
lord.
have to oppose this.
This is not.
This is not, my
Now,
lord, fairness.
you'd come on the merit of the matter,
My lord, I
whole
was
hog
not
we will
willing-
hear
I
it.
was not at all willing to
No,
say this.
no names, no aspersions on anybody, come on merits.
My lord,
Yes.
very
I
well.
expect that from you, madam. Yes,
I apologize.
yes.
My lord, they may respond on Tuesday.
They will, don't worry. I'll post it on Tuesday.
My lord, may kindly fix the time because
Why?
my lord,
Have I not taken it today?
my lords
Then
have taken.
don't worry, every matter will reach before this court.
Your
You've been
lordship,
seeing.
500 matters, your lordship have reached.
My lord,
That is why I said all this.
No,
my lord,
no,
is
she is
very
literally here every day. She knows it.
Insinuations, my lord, in a very subtle manner. That's what, my lord, I
My lord,
oppose.
that's
Don't see
only a slip of
that
tongue.
those
my lord.
on senior advocates,
Sorry.
senior advocates of this court, no, nothing. No, don't take names, no mentioning. You argue on merits, I will answer on merits.
I apologize. Obliged.
Yes. Tuesday, we'll post it for further hearing only. No time, it will reach. Yes.
He could pass over, my lord. Senior counsel, Mr. C.V. Nagesh is on his legs before another court.
ಯಾವ್ದಿದು?
131.
Magic Act.
Oh, black magic, yes.
Lord, I seek for a pass over. Senior
ಅಷ್ಟೇನಾ?
counsel is
So
on
you
his
have to
legs.
do some black magic. Yes. ಎಷ್ಟು ಸರಿ ಪಾಸ್ ಓವರ್?
He's,
ಅವರು ಹೇಳಿದ್ದಾರೆ, ನೀವು ಹೇಳ್ಬೇಕು.
Please, my lord, I'll, my lord.
Start. I have heard him. Ask him to come. Don't worry. Yes. Let him join. No issues. ಅವತ್ ನೀವು ಇರ್ಲಿಲ್ಲ. He has made his submissions. ಒಂದಿನ ನೀವು ಮಾಡಿದ್ರಿ, ಅವರು ಇರ್ಲಿಲ್ಲ.
May kindly, my lord, the petition which is, my lord, filed by the, one is, my lord, the writ petition number 18/687 and.
Now there are three petitions.
The three petitions.
First
Lord,
petition,
First petition, my lord, is the petition filed by the husband.
husband.
Who is seeking, my lord, for quashment of proceedings and
That is
498.
9653.
That is,
Husband.
that is by the husband and the mother-in-law. That is, my lord, sought to quash the charge sheet which has been submitted on the complaint filed by the respondent number 2 wife.
All right. First 9653 is husband and mill.
Husband, please.
Then.
In that proceedings, my lord, the FIR came to be registered based on the complaint of the respondent number 2, which is at Annexure A, page number 19, which is for the offense under 498A, 323, 334, and my lord, 3 or 4 of the DP Act. And in that complaint, my lord, the respondent number 2, my lord, makes an allegation, and her complaint is reduced at page number 23, Annexure B. The sum and substance of the allegation, my lord, is that she was married on the year 2018, and there are, my lord, the children born. And parent number 2, at the time of my marriage, my husband and my wife and his family had demanded that they wanted to have a big fat Muslim wedding. Even though at the time of wedding we are going through financial crisis, my father tried at all his best efforts to fulfill their wishes. On demand, our nikah marriage took place at so and so, Bangalore, and the reception was very next day in the same place. The marriage was registered under Special Marriage Act on so and so. All the expense of my wedding was solely borne by my father. Further, my father's husband's family demanded for expensive furniture, and my father spent around rupees 3 lakhs to fulfill their lavish demands. My husband even asked my parents to make an accommodation to all the guests from the groom side in a lavish hotel. My father thereby spent around rupees 1.5 lakhs and booked rooms at Confident Pentagon at Bangalore to lodge my in-laws' guests. My mother-in-law, number 2, demanded that my father should give at least 1 kg of gold at the time of the wedding as a dowry. And fails to do so, they will call off my wedding. And thereafter, my father have no other option, succumb to the said demands and somehow managed to give 500 grams of gold to my husband. Even after commencing the marriage, my husband and my family were not satisfied with the dowry sought. Day by day, their demand started to increase. My husband wanted to invest in a business for which he wanted a huge amount, and for the same, he started to demand with my father. Apart from dowry demands, my husband used to constantly abuse me physically and also use foul language to me and my family for not getting enough dowry. My husband was supported by his relatives, including his mother, so and so. My mother-in-law used to independently assault me and also instigate my husband to physically assault me and also abuse me for getting more dowry. She created a hostile environment at home and ensured that my husband pushed me out of the house. I was put under severe physical and mental cruelty to the said actions, and my husband and his mother.
All against husband.
All against husband. And Milord, that's against mother-in-law will say that she had instigated the husband.
Mother-in-law, it's instigation.
Please. And insofar as the thing is concerned, Milord, why the petition was filed with this honorable court is the two petitions and the 2 other petitions which are connected. Milord, they had a conspiracy, Milord, to do away the life of the mother-in-law, accused number 2.
Do away the life of the mother-in-law.
Mother-in-law.
So Black Magic Act.
Milord, for that, the modus was, Milord, to steal the jewelry and the money from the husband's house. And Milord, the wife, Milord, would give it to the other accused. Milord is the concubine. Milord, I will establish that. And he would, Milord, take those articles of jewelry and cash. And Milord, engage, Milord, the services of one, Milord, a person who is included in, Milord, in the black magic practices. To do, Milord, there are sufficient, Milord, discussions onto that effect. Page number 61 may kindly be seen, Milord, Annexure H. This is, Milord, the discussion between the WhatsApp chats between, not exactly WhatsApp, Milord, there's another app which was being used.
WhatsApp alva.
So not a WhatsApp, it was another application which was used. And Annexure H, page number 61. The block, Milord, in top. Aito did not wanted that lady to see my son. She refers to, Milord, the mother-in-law. Then coming forward, Milord, at page number 62. if you leave me also, I'll never leave you. Yeah, I do not have attachment with you. My lord, that is, my lord, the
Husband.
my lord, not with the that person, my lord, and her. If you can use, my lord, what as concubine, my lord, she had a illicit affair with that person. Do away with his life, my lord. That's my lord. Second, my lord, page number 63. He, my lord, writes, you see in cousin's pocket or any other where you get. My lord, he is trying, my lord, to tell her to not steal certain money from the cousin's pocket, from the house of my lord husband. Then, my lord, what article is being given at page number 63? My lord, he weighs that gold and my lord, he sends the image that it is only 907.2 grams. It is not sufficient. Not the husband, not that person who is in contact with my lord, the wife.
Oh, that third person.
Third person. He is, my lord, instigating, my lord, coordinating with her, taking the gold and the jewelry and the money.
He's a goldsmith.
No, my lord, not. My lord, he sells it, my lord, in the market, takes money, and under that, my lord, engages, my lord, what discussion is 75 lakhs. My lord, no one can take a life. 1 crore is required to take away do away with life of a person. Not all the discussions are there.
For black magic, 1 crore has to be spent, is it?
That's what my lord is said, my lord, very unfortunate. But my lord, that is not mentioned. And may kindly see, my lord, page number 68. Clearly, my lord is mentioned for life taking, you will ask for 1 crore here. Maximum 75 lakhs. That is not really 68.
So they conspired to take away the life of the mother-in-law.
And when, my lord, that was found, the phone, my lord, is purchased by the husband to the wife. That, my lord, phone is taken by him. He finds out all these things. My lord, immediately, my lord, this thing has started filing a 498A complaint. Before that, my lord, about 15 days ago, my lord, a petition under the GNWC was filed. An interim order was obtained.
GNWC is filed by whom?
Filed by the wife.
Okay.
And interim order was obtained. Thereafter, my lord, after a span of about 20 days, my lord, the complaint can be filed. And therefore, my lord, this chats, my lord, clearly show that, my lord, what was the modus, my lord, of the wife. And, my lord, when she, my lord, was caught red-handed doing all these things, and it happened almost 2 years ago. My lord, I was under impression that one of the servant, my lord, has stolen the article. And the complaint came to be filed for the, my lord, theft of these articles against a servant, which is at page number 74 and 75. And when, my lord, that investigation happened, my lord, the police, my lord, found out that she had not, my lord, committed the offense. Because one within the house, the daughter-in-law, my lord, would my lord, take away all these articles, give it to, my lord, the accused number 2 in the connected matter. She would, my lord, receive these articles, my lord, and my lord, prepare, my lord, for these black magic practice. At this stage, my lord, the FIR private complaint was filed and the FIR was registered, and, my lord, there is investigations pending. As on today, my lord, investigations pending in their matter. In this matter, my lord, the charge sheet has been submitted.
Yes, in the first matter.
Please, charge sheet has been submitted.
Against the mother-in-law and husband, charge
Please,
sheet
charge sheet has been submitted.
In the other matters?
Other matter, my lord, investigation was pending. Charge sheet is not yet filed. Based on the private complaint, my lord, the FIR was registered.
Interim order is operating.
Please, my lord, all the 3 matters, my lord, interim orders.
In this also interim order. So this is all your submission.
Please.
Including the submission in the other cases.
Other cases, my lord, my only submission, my lord, insofar as the provisions of the act are concerned.
Black magic
Please.
act. Now section 3 is alleged.
Please, madam.
Come to section 3.
Section 3.
Prevention and eradication of inhuman evil practices and black magic.
Please. What would, you know, no person shall himself or through any other person commit, promote, propagate or practice or cause or promote, propagate or practice inhuman, evil practice and black magic specified in the schedule.
What is specified in the schedule?
Schedule, please. Schedule, my lord, the items may kindly be.
No, it is there.
Please. And under subsection 3, one is that, my lord, he is coordinating with the person to whom, my lord, taking money from this this lady, from the respondent number 2, taking jewelry, taking the monies and coordinating with him, and there's continuous, my lord, discussion with regard to life taking of, my lord, the mother-in-law. That is, my lord, clearly spelled out in, my lord, the chats which I, my lord, just read out. Not, my lord, 1 or 2, my lord, numerous chats are there which clearly depicts, my lord. And thereafter, my lord, what says, my lord, whoever abets the commission or attempts the commission of any act or promotes, my lord, they clearly fall under this definition of, my lord, having practice and promoting, my lord, such kind of a evil practice. Therefore, my lord, section 3 is clearly made out. Therefore, my lord, on that contention, my lord, their petition may kindly be discussed. That's, my lord, my submission.
Yes, sir. Since you had submitted for some time when he in his absence.
My lord, I'm sorry. Kindly accept my apologies. I was
No
whatever
problem.
held up
He
in
was
quotal number
fine.
6.
That's all right.
I'll accept. Well, basically, the offense that is alleged is one under section 307,
Attempt to murder.
attempt to murder. Well, how the courts have said, my lord, with regard to the attempt is, but for some intervening cause,
302 Act, right?
had the act been completed, ಅದು 302.
302.
ಅಲ್ಲ ಇಲ್ಲೂ ಅಷ್ಟೇ 307 ಆಗ್ಬೇಕಾದ್ರೆ ಬಟ್ ಫಾರ್ ಸಮ್ ಇಂಟರ್ವ್ಯೂನಿಂಗ್ ಕಾಸ್ ಹ್ಯಾಡ್ ದ ಆಕ್ಟ್ ಬಿನ್ ಕಂಪ್ಲೀಟೆಡ್. ಇಲ್ಲಿ ಇಂಟರ್ವ್ಯೂನಿಂಗ್ ಕಾಸು ಇಲ್ಲ, ಆಕ್ಟ್ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ. ಐ ಆಮ್ ಶೂರ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ವುಡ್ ಸರ್ಟನ್ಲಿ ಅಗ್ರಿ ವಿತ್ ಮೀ. ಅಟೆಂಪ್ಟ್ ಇಸ್ ಟೋಟಲಿ ಡಿಫರೆಂಟ್ ಫ್ರಮ್ ಪ್ರಿಪರೇಷನ್. ಪ್ರಿಪರೇಷನ್ ಡಸ್ ನಾಟ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ an act of attempt. Illi. What is 307 according to them? Attempt to commit murder. How? In what way I did it? There must be a basic minimum allegation for the court to have noticed the commission of a cognizable offense for the purpose of making an order of reference under section 156(3). No. Exchange of messages. Kindly proceed with an assumption for the sake of argument, do not considering for a moment at this point of time that there are certain exchange of messages. Subsequent to the exchange of messages, there must be some act.
So it remained at messages only.
Ashte. My lord, I don't know how your lordship would recall to your lordship's memory under the provisions of the Essential Commodities Act under section 3 and 7. The state government would issue certain notifications
under 7.
prohibiting interstate or interdistrict movement of
Prohibiting
goods
many
and all
things
that.
under 7.
Many, yes.
Which becomes an offense under section 3.
Well, supposing I load the food grain into the lorry, it does not constitute an offense. It is only a preparation. In the last minute, my lord, I may realize, look here, what I am doing is incorrect. I will unload it. Then it will not constitute an offense at all. It is not an attempt. It is only a preparation. Now, attempt for what? Black magic is for what? To see that she is subjected to some kind of torture or harassment.
That is why, if I may say, 399 and 402 are differently worded. Preparation and attempt.
Alve. Innonsari nodona idralli. My learned friend, my lord, invited my lord's kind attention to schedule class 3, alva? Schedule 3. No.
Whoever attempts.
Alala. No, my lord. No.
Schedule of the act.
Schedule.
No.
Constitutes offense.
No. Idralli goes to.
Under the pretext.
I don't know. Probably in Gudiyaman, my learned friend might have invited my lord's under the pretext
Expelling the ghost, assaulting by tying the
assaulting by tying the person with a rope or chain, beating by stick or whip to make the person drink footwear, soaked water, giving chilly smoke, hanging a person to roof, fixing the roof.
Under Milord, under provision
Or
2.
by hair or pluck his hair, causing what is all
That is
this?
different, Milord, because what happens, Milord, schedule has Milord item number 1 to 16.
ಅಲ್ಲ, ಮುಂದೆ ಓದಕ್ಕೆ ಆಗಲ್ಲ.
ಮುಂದಕ್ಕೆ ಓದಕ್ಕೆ ಆಗಲ್ಲ.
ಅಲ್ಲ, ಓದೋಕ್ಕಿಲ್ಲ.
ಇಲ್ಲ, ಯಾವ್ದಾಗಲ್ಲ. If at all, my lord, at the worst, if we take the entire, my lord, allegation to its face value as true, it should come within the parameters of 1, 2 and 3.
Please.
Beyond it ಬರೋದಿಲ್ಲ. I'm sure my learned friend would certainly fairly
ಆಮೇಲೆ
concede.
ಬೇರೆನೇ ಇದೆ.
ಬರೋದಿಲ್ಲ, ಯಾವ್ದು ಬರೋದಿಲ್ಲ. ಒಂದ್ ನೋಡೋಣ, performing completion. Inhuman, evil act and black magic in such of precious things, bounty and hidden treasure, or for similar reasons in the name of such as Banamati, Mata Mantra, assaulting any person, parading naked, or put a ban on his daily activities, or instigate, advise, or encourage committing of such inhuman acts. Ilbarala. Now, my lord, kindly go to 2. To create an impression by declaring that a power inapprehensible by senses has influenced one's body, or that a person has possessed such power, thereby create fear in the minds of others, or to threaten others of evil consequences for not following the advice of such person, or deceive, defraud and deter him. ಎಲ್ಲಿಗೆ ಬರ್ತಿದ್ದು? ಏನ್ ಮಾಡಿದೆ ಅಂತ 1, 2, 3 ಬರೋದಿಲ್ಲ, ಬಾಕಿದ್ರಷ್ಟು ಇಲ್ವೇ ಇಲ್ಲ.
ಬಾಕಿದವರು
ಬರೋದಿಲ್ಲ. ಇದು ಕಂಪ್ಲೀಟ್ ಆಗಿದ್ದಿದ್ರೆ, ಇದು ಯಾವ್ದಾದ್ರು 1, 2, 3 ಕಂಪ್ಲೀಟ್ ಆಗಿದ್ದಿದ್ರೆ ಆವಾಗ 307 ಆಗ್ತಾ ಇತ್ತೋ ಏನೋ, ಅದು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ಇಲ್ಲಿ 307 ಏನು? Well, now kindly see 380. Yes, alleged 380. Theft of jewelry. When? About 4 years ago. Not today. About 4 years ago, I stole the jewelry.
Mother-in-law's jewelry.
Complaint ನನ್ನ ಮೇಲೂ ಇಲ್ಲವೂ ಇಲ್ಲ. ಸರ್ವೆಂಟ್ ಮೇಲೆ ಕಂಪ್ಲೇಂಟು. ಈ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಆಯ್ತಲ್ಲ, 3 ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಆಯ್ತು. ಫಸ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ವಾಸ್ JNWC, ಕಸ್ಟಡಿ ಆಫ್ ದ ಚಿಲ್ಡ್ರನ್. ಅದು ತಗೊಂಡ್ವಿ ನಾವು, ನಮಗೆ ಕೊಟ್ಟರು ಕೋರ್ಟ್ನವರು. Second proceedings was filing a complaint against him for an offense under the 490/80 and 3/4 of the Dowry Prohibition Act. Third proceedings ಏನಾಯ್ತು ಅಂತಂದ್ರೆ, I would file a petition against him seeking for a decree of divorce on the ground certain allegations which I have made. ಆಮೇಲೆ ಈ ಕಂಪ್ಲೇಂಟ್ ಅವ್ರು ಸ್ಟೇ ತಗೋಬೇಕಾದ್ರೆ some inaccurate submission has been made stating that he has filed a complaint against me. Therefore, I have filed a complaint against. No, that is incorrect. I can give you, Your Lordship, the dates. Have a look at the dates, madam.
No, first petition for divorce is by you.
My complaint was of mine, petition was mine, everything was mine. Avurdu after thought. Idella ಆದಮೇಲೆ he goes and files a private complaint. In fact, my lord, what the Supreme Court has said is, we have a common notion that under section 468 of the CRPC, my lord, the prohibition is imposed only upon the court. No court shall take cognizance of an offense excepting upon a complaint filed within a period of so and so. ಇಲ್ಲಿ theft ಏನು ಅಂತಂದ್ರೆ, the maximum punishment that is permitted under the law is 3 years. ಇವ್ರದ್ದು ಅಫೆನ್ಸ್ ಯಾವಾಗ ಆಗಿದೆ ಅಂತಂದ್ರೆ 2020 ಜನವರಿ.
ಕಂಪ್ಲೇಂಟ್
ಫೆಬ್ರವರಿ 2023. ನಮ್ದೆಲ್ಲ ಆದ್ಮೇಲೆ
1 month after the limitation.
ಅಲ್ಲಿಗೆ they can't contend that it is a case there is a prohibition imposed upon the court from taking cognizance. Even a prohibition is imposed upon the policeman from taking the complaint is a law laid down by the Supreme Court.
No. That should not be mistaken. Cognizance can be taken after 10 years.
ಮಾಡ್ಬೋದು.
It is the act of the complainant to file a complaint within
ಇಲ್ಲಿ
limitation.
what is
That is not the law is that cognizance ತಗೊಳಕಲ್ಲ. Complaint ಮಾಡಕ್ಕೆ 3 years ಒಳಗೆ ಮಾಡಿರ್ಬೇಕು.
the period. But what the Supreme Court has said is, even when you go before the police, you should be well within time.
Yes.
The period that is prescribed is what the Supreme Court has said.
The complaint is entertained. The court at its own ease takes cognizance after 7 years. That would not absolve the
ಅಲ್ವೇ?
accused.
ಅಲ್ವೇ?
It is only
The policeman ought not to have registered the crime at all. But that is what the Supreme Court has said.
ತಾರಾ ಮ್ಯಾಥ್ಯೂ ಅಲ್ಲಿ ಹೇಳಿರೋದೇ.
ಅಲ್ಲ, ಇದರಲ್ಲಿ ಭರತ್ ದಾಮೋದರ್ ಕಾಳೆ ಕೇಸ್ನಲ್ಲಿ this is what the Supreme Court would say in paragraph 10.
No, the constitution bench in Sarah Matthew clarified this, saying that it is not, limitation does not run on the date on which the court takes cognizance, but on the date on which the complainant registers the complaint.
ಅಲ್ವೇ?
Cognizance ಗೂ 468 ಗೂ ಸಂಬಂಧನೇ ಇಲ್ಲ.
Otherwise, my lord, everybody would contend for no fault or sin on my part on account of some laches negligence on the part of the court. Why should I be thrown?
No, that is why Supreme Court has clarified. Cognizance has nothing to do with limitation.
Well, just refresh my lord's memory. I shall read this only 2 or 3 sentences from this paragraph 10, my lord. On fact of this case and based on the arguments advanced before us, we consider it appropriate to decide the question whether the provisions of chapter 36 of the code apply to the delay in instituting the prosecution or to the delay in taking cognizance, as my lord has pointed out. As noted above, according to the learned counsel for the appellants, the limitation prescribed under the above chapter, that is 468, 469, 470, 471 and onwards, chapter applies to taking cognizance by the court concerned. Therefore, even if a complaint is filed within the period of limitation mentioned in the said chapter of the court, if the cognizance is not taken within the period of limitation, the same gets barred by limitation. This argument, well, it seems to be inspired by chapter of the heading in chapter 36 of the code, which reads thus: limitation for taking cognizance of certain offences. It is primarily based on the above language of the heading of the chapter.
No, that is, I have not prescribed to that at all till now.
The argument addressed on behalf of the appellants that the limitation prescribed in the said chapter applies to taking of cognizance and not filing of the complaint or initiation of the prosecution. We cannot certainly accept such argument because a cumulative reading of various provisions of said chapter clearly indicates that the limitation prescribed therein is only for the filing of the complaint or the initiation of the prosecution and not for taking cognizance, as my lord has pointed out.
There is a judgment of the coordinate bench which says cognizance runs limitation.
ಇಲ್ಲಿ
Cognizance will ಎಷ್ಟೋ ಸರಿ ಇಲ್ಲ, magistrates will not have taken cognizance for 10 years.
ಬಿದ್ದಿರ್ತಾರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಫಾರ್ ಒನ್ ರೀಸನ್ ಆರ್ ದಿ
ಹಾ, ಮತ್ತೆ
ಇವರು ಇದು ಅಫೆನ್ಸ್ ಡೇಟ್ಸ್ ಬ್ಯಾಕ್ ಟು January 2020.
all right.
ಇವ್ರ ಕಂಪ್ಲೇಂಟ್
24. That will see, will answer that.
ಅಲ್ವೇ
23, please.
23 February
February
2023.
Offense
But
record of major
what I
offense.
would do theft of jewelry ಇವ್ರು ಹೇಳುದು ಅವ್ರ ಮದರ್ ಇಲ್ಲ ಅದು ಅವ್ರ ಮದರ್ ನಾವು ತಗೊಂಡ್ಬಿಟ್ಟಿದೀವಿ ಅಂತ. But I would file a complaint complaining of certain offenses under 498A 3 and 4 of the dowry prohibition. In my complaint, I would say, my lord, the jewelry, costly jewelry worth more than about 1.5 crores was given to my daughter. Now the Tanishka now, I am the proprietor of Tanishka jewelry now. ನಮ್ಮ ಮಗಳದು ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತಿದೆ. During the course of investigation, what the investigator does, he would seize certain ornaments which were in the house. And then ultimately the court would deliver those custody of those jewelries to me. My lord, 2 bank lockers were found by the investigator during the course of the investigation. He would issue a communication to the banker saying that till I issue further orders, do not permit opening of the lockers. But in the meantime, he would rush before this court even before the lockers are opened and get an order of stay of recording of further proceedings. But if these 2 lockers are opened, my jewelries are there. Probably, my lord, his mother's jewelry may also be there. I do not know. Maybe there. Kindly let him consent in all fairness and in fitness of things. Kindly issue a direction to the investigator to open the lockers. Let us see whether his jewelry, which he has described in the complaint, is available there or not. 2 ಲಾಕರ್ ತುಂಬಾ ಇದೆ. ನನ್ನ ಜ್ಯುವೆಲ್ರಿ 2 ಲಾಕರ್ ಇಟ್ಕೊಂಡಿರೋದು ಮನೆಯಲ್ಲಿ ಬೀರುನಲ್ಲಿ ಇಟ್ಟಿದ್ರಂತೆ ಅವ್ರ ತಾಯಿ ಜ್ಯುವೆಲ್ರಿ. ಮೇಲೆ ಇಟ್ ಲುಕ್ಸ್ quite recently, just about a week back, I remember to have read a judgment of the Kerala High Court which said, my lord, an allegation simpliciter in the complaint is always there that would constitute an offense. But what needs to be examined by the court when it exercises jurisdiction under 482 or under 226 of the Constitution is the overall picture, the overall circumstances.
So that's what the Supreme Court, not
Just
Kerala High
last
Court.
week.
Muhammad Ali versus State of Uttar Pradesh.
Following that judgment,
Justice Perjural has said, it is the duty of the court exercising under 482 to read between the lines, look at the attendant circumstances, then see whether the offense is really made out. Merely because a cognizable offense is made, don't dismiss the
you're going to
cases.
complain, my lord, it is easier to make an allegation my lord, indicating the commission of a crime. Oh, I have the jewelry, he has committed theft about 3 years back. About Alve. The totality of the circumstances, the backdrop of the matter, I go before the court, I file a complaint, but I file a divorce petition, I wanted the custody of my children. Later in point of time, my lord, he would come up with a complaint against me, complaining of an offense of theft, and then attempt to commit murder, and then, my lord, an offense under section 3 of the Karnataka Black Magic Act. My lord, ಇಲ್ಲಿ ಒಂದು ಸ್ಟೇ ಆರ್ಡರ್ ಕೊಟ್ಟಿದಾರಲ್ಲ ಅವರಲ್ಲಿ 498A ನಲ್ಲಿ. Kindly have a look at that, my lord, the order.
ನಾನೇ ಕೊಟ್ಟಿರೋದ?
ಇಲ್ಲ.
Gold ornaments also consent to do away with the life of the mother-in-law.
No, my lord, this is the order.
6/10/2023.
Yes, my lord, 610. Kindly read. Learned counsel for the, I don't say, my lord, it is a false statement. I don't say it. It is an inaccurate statement, I would only say. Incorrect statement, I would say. This has probably swayed in the mind of the court to grant an interim order.
The coordinate bench.
Learned counsel for the petition submitted, the petition number 1 has lodged the FIR against the second respondent, alleging committing of theft of gold ornaments and also conspiring to do away with the life of the petitioner number 2 mother-in-law. Thereafter, the second respondent has lodged.
Actually, the other way.
Incorrect statement.
Pointing out, not the, what I pointed out.
ನಾನೇ ತಪ್ಪು ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ, ಸುಳ್ಳು ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ. It is this, my lord.
To produce, not the complaint. I have not, my lord.
All right. I am not finding fault with you, sir. ಎಲ್ಲಾದ್ರೂ ಉಂಟಾ?
Please.
ನಾನು ಹೇಳೋದೆ. Probably the court, the coordinate bench of this court, my lord, might have been swayed by this and granted stay. ಅದರಲ್ಲಿ ಲಾಕರ್ ಓಪನ್ ಮಾಡಕ್ಕೆ ಅವಕಾಶ ಆಗ್ತಾ ಇಲ್ಲ. ಎಲ್ಲ ನನ್ನ ಜ್ಯುವೆಲ್ಲರಿ 1.5 ಕೋಟಿ ರೂಪಾಯಿ ನಾನು ತನಿಷ್ಕ.
We'll decide it once for all. Now
Your lordship may.
you can open all the lockers.
Yes.
Ashtana? Heard the learned counsel.
Probably whether the provisions of
that I am going to answer.
Yes.
Black Magic Act, there is no judgment.
ನಾನು 2 ಜಡ್ಜ್ಮೆಂಟ್ ಸಿಕ್ತು ನನಗೆ. ಒಂದು ಮಹಾರಾಷ್ಟ್ರದು, ಇನ್ನೊಂದು ಗುಜರಾತ್. ನಾಟ್ ಅಂಡರ್ ಸೆಕ್ಷನ್ ಇದರಲ್ಲಿ ಬ್ಲಾಕ್ ಮ್ಯಾಜಿಕ್ ಆಕ್ಟ್ ಅಲ್ಲ. But whether the provisions of the Maharashtra Black Magic Act or the Gujarat Black Magic Act are in parameteria with Karnataka Black ನೋಡಿದೆ ಇಲ್ಲ. ಅದರಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತಂದ್ರೆ they will issue a direction.
Black magic in every state differs, so it can't be the same.
ಇಲ್ಲ, ಅದಕ್ಕೆ ನಾನು they are not in parameteria. Even otherwise in that judgment, my lord, what the Maharashtra High Court would say, Bombay High Court would say is it would issue certain directions to the state government to frame certain rules.
ಇಲ್ಲಿ already ಇದೆ.
ಇದನ್ನ ಆನ್ಸರ್ ಮಾಡಿಲ್ಲ ಇದನ್ನು.
It should be the first judgment.
The first judgment. ಅದಕ್ಕೋಸ್ಕರ my lord, I may win, I may lose. That is not the issue. If my lord were to lay down the law, my lord, that would be of some use for future litigation.
Yes. Unless I am hit by blackmail. Yes. Heard the Learned Counsel so and so and Learned Senior Counsel C.V. Nagesh appearing for the respondents. All three matters reserved.
Please.
Yes.
Oblige. Interim order in my
Interim
case-
order subsisting in any of these cases in the form that it is subsisting continues till the disposal of the petition.
Please. Sorry, my lord. Because
No
unavoidable.
problem, sir. ನಿಮ್ಮನ್ನ ಕೇಳಿದ್ನಲ್ಲ ಅವತ್ತು, ಅದಕ್ಕೆ ಅದನ್ನ ಹೇಳ್ತಾ ಇದ್ದೆ.
ಅದು ಅಲ್ಲಿ ಈ politicians.
ಓ, ನೀವು ಆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇವರು ಅಲ್ಲೇ ಇದ್ರೇನು? ಓ ಸರಿ.
ಹೌದು, ಇಬ್ರು ಅಲ್ಲೇ ಇದ್ವಿ.
ಅದೇ.
I was relieved by 4:25.
Yes, sir. ಏನಾಗಿದೆ ಮೇಡಮ್? ಐನಾ? ಫಸ್ಟ್ ಮಾಡಬೇಕು 14%. ಮತ್ತೆ ತೆಗೆದಿದ್ದಾರೆ ಪೇಪರ್, ಹೊಸದಾಗಿ ತೆಗೆದಿದ್ದಾರೆ. ಈಗಲೇ ವೆಬ್ ಪಾಸ್ ಮಾಡಿ, ಈಗಲೇ ವೆಬ್ ಪಾಸ್ಟ್ ಈಗಲೇ ಮಾಡಕ್ಕೆ. ವಿತೌಟ್ ಪಾಸ್ ಅವರ್ ಆಗೈತಲ್ಲ. ಸೆಟಲ್ಮೆಂಟ್ ಯಾವುದು? 3 ಇದೆಯಾ? ಥರ್ಡ್.
more matters?
1 to 4, 1 to 5 in terms of the memo withdrawal. The 1, 2, 4 and 5 in terms of the memo.
Shekhar, please.
Madam, 1, 2, 4 and 5 in terms of the memo. Yeah, move ಮಾಡಿ. Yes, sir.
Now, what is challenged before your lordship is the order of the learned magistrate passed while implementing the order passed by this court in a revision petition. The facts are like this, my lord. The respondent, wife, filed a petition under section 12 of the Domestic Violence Act, page 31. At page 43, the prayers. First prayer is under section 8, protection orders. Second prayer is under section 19. C is most relevant. Section 19F, directing respondent number 1 to secure same level of alternative accommodation.
Page 112.
Huh?
Page 112 of the order.
112.
Yes, sir.
Miller.
Page 112.
Yes.
You're talking of that?
Yes.
Yes, 112.
112 is the order of in revision.
That is what was sought to be implemented now.
What is sought to be implemented. Milord, the point is this.
Yes.
She sought for alternative accommodation under section 19(1).
Yes.
Then she files an application under section 17.
Yes.
In the 17 application, magistrate passes an order. The property where she was living in 2014, Milord, she files a petition in 2040-50. And she files a 17 application in 2017. Magistrates allows the application for maintenance, grants 2,000. And so far as this is concerned, she said it's a mother's district, and alternative accommodation is ordered to be given. And immediately a memo is filed by the respondents in the court that alternative accommodation will be provided. She goes in appeal, challenging that order. In appeal, the maintenance is enhanced to 5,000 rupees. That was in the criminal petition. It is ready
That
to
all
forward.
this has
We are
happened.
not concerned with
We
that.
are only on page 112 and its implementation.
112 and its
Now the
implementation.
court says provide separate residence in her matrimonial home.
That is his order. That order is to be challenged, cannot be challenged before this court again.
No, it is here only.
That is a matter to be challenged before the Supreme Court.
Yes.
An application was made to postpone this implementation by 2 months.
Where is that?
That is the order, my lord, your lordship will see. The application was filed, page 113. The order at page 22.
Application for grant of time.
Grant of time.
That is rejected?
That is rejected. Your lordship will get at page 26.
Now, are you providing accommodation to the wife or not?
We will provide alternative accommodation. Building on a more portion is some. What happens when he goes in revision, she proceeds only against the husband. Parents are given up. See, before.
I know, only husband is the respondent.
Only the husband is the respondent.
Before the DV Act court, all of them were there.
All of them were party.
In revision, only husband is party. Against the husband, the court directs that a residential accommodation should be given, page 112.
Page 112.
You seek time, that is rejected.
Yes.
Now you are giving accommodation or not?
You will give accommodation.
Where?
My lord, the magistrate's order is, there are 2 rooms and a common hall and a kitchen. Provided 1 room,
correct,
common hall and kitchen, they should not disturb our use of it. That means they should not use any one of them.
Provide a room, common hall, and it's common. So that's all
My
right.
lord, my respectful submission to your lordship is, her prayer in the petition itself was for alternative accommodation. Alternative
Now,
accommodation.
what is the urgency to move it at 2:30?
Building of, they will come and throw us out and put her inside.
All right, you serve the wife. I will direct status quo to be maintained as on today till Tuesday.
Till Tuesday, your lordship may have. 2 days I am out of state.
When do you want?
Your lordship, Friday, sir.
Next Friday.
Friday.
But where is the wife staying now?
Wife staying in Banakal, Bangalore.
Bangalore.
She's a practicing lawyer. She's a practicing lawyer. She uses oral knowledge to see that these people are. Ali Maniolaga 3 floor is Azami. Ground floor is tenanted.
What practicing lawyer or whatever it is, but accommodation should be given.
No, accommodation will be, they have been saying.
Where is she staying today? Where is she staying today?
Right, my lord. She married in October 2014.
ಇವತ್ತು ಎಲ್ಲಿ ಇದ್ದಾರೆ ಅಷ್ಟೇ ಹೇಳಿ 14 ಗೆಲ್ಲ ಯಾಕೆ?
December 14 she is staying in her parents' house. Not in this shareholder house at all.
Then the
December 14 onwards.
coordinate benches order is implemented.
Coordinate.
Benches order is implemented.
This order is passed on 30th May. That implementation order is passed by the magistrate now.
ಎಲ್ಲಿ accommodation ಕೊಟ್ಟಿದ್ದೀರಾ ವೈಫ್ಗೆ?
ನಾವು ಕೊಟ್ಟಿದ್ದೀವಿ, ನಾವು ಮೆಮೊ ಹಾಕಿದೀವಿ, ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತ ಹೇಳಿದೀವಿ. We have taken one on rent. At page 115.
Now you serve the wife and get her.
Hello.
It's better to hear the wife. Yes, they heard the learned senior counsel Thomas Sebastian appearing for the petitioner. The learned senior counsel would submit that the coordinate bench in criminal revision petition 229 of 2022 had passed the following directions, page 112. An application was preferred before the concerned court seeking extra time to implement the order, to comply with the order quoted supra. That is rejected. Therefore, the petitioners are before this court. The learned senior counsel would submit for the last 10 years, the wife is residing in the matrimonial house.
Not in the matrimonial house.
Sorry, in the parents' house.
Her parents.
In her parents' house. And therefore, the time was required to set up an alternate accommodation to her, as her prayer before the concerned court was only for alternate accommodation. In that light, the learned, the wife be served by way of hand summons. Who is the second one? Second respondent.
Is the husband. You will be served formally.
You are the in-laws, huh?
In-laws.
Oh, sorry.
Parents.
ನಿಮ್ನೆ ಆಚೆ ಹಾಕ್ತಾರೆ ಆಮೇಲೆ. Yes. So and so. Wife be served by way of hand summons till the next date of hearing. Wife is served by hand summons. List on 5th in the fresh matters list till such time status quo as obtaining today be maintained by the parties. Four and five withdrawal. 5.1 ಎಲ್ಲ ಅದೊಂದು ಮಾತ್ರ ಸರಿ ಅದು ಹೇಳ್ಬಿಡಿ ಅವ್ರಿಗೆ ಇದು ತಗೊಳ್ಳಿ ಲಕ್ಷ್ಮೀ ರಘುವನ್ ಸರ್ ಬಂದ್ರ ನಾಟ್ ಕಮ್ ಎಸ್
I apologize.
ನೋ ಪ್ರಾಬ್ಲಮ್ ಇನ್ನೊಂದು ಹಸ್ಮತ್ ಪಾಷಾ ಸರ್ ಇದ್ರಲ್ಲ ಬರ್ತಾರಾ ಸರಿ ಎಸ್
My lord, on the last occasion, if your lordships will, as your lordships will recall, my lord, two things happened. One, my lord, we brought to your lordship's kind consideration that there was a divorce granted in accordance with the Russian law by the appropriate officer in Dubai. And what was told to your lordship was that, what is this divorce? I don't know anything about it. I came to know about it only when the writ petition was filed. I didn't know anything about it.
Yes.
And the question that was put to the other side by your lordship was, when you came to know about it, what have you done when you say you don't know? And they said, we have filed some complaint. So I would like the other
Complaint.
side. Yes, I want to know what they've
Complaint
done.
in Dubai.
Yes, I want to know what they've done. And if they have really said something there is something, see, I want to tell your lordships, my lord, and I will do it after they have put their stand on affidavit.
Which one?
On what they have done. They have put on affidavit before your lordships that they came to know about this whole thing, about the divorce in Dubai.
Yes.
Only when this writ petition was filed and all that. My lord, I have material to show that long before the respondent has said, I went to the consulate in Dubai for the divorce. And if they're going to put that in affidavit, my lord, I will make out a case for perjury against them. But this is a serious issue. Your lordships are looking at it on the basis of affidavits in a matter like this kind. Normally, my lord, I would not have made this strong submission. But given that a statement was made that I never, what is this? Everything is forged. I don't know anything about what is happening in Dubai. I have material to show that she has said, yes, I went with you and I have signed the papers there. And in fact, we are also in the process of getting documents to show that in fact, she has signed I'm given to understand, my lord, that in Dubai, they have a register which enters people who go in and come, as usual, my lord. I mean, many of the offices where we have to sign and give the details before we enter the office, that is there. And as your lordship saw last time, my lord, we in fact produce a copy of it. They give a certificate, one certificate to the husband, one certificate to the wife, dissolving the marriage. She has acknowledged having taken the we are in the process.
Certificate.
We're getting it, my lord.
Certificate.
Yes. Lord, this is the position. Yes. And now, my lord, we also have our reply, rejoinder. We'll file it. We are producing all those documents. The document to be got from the consulate, my lord, we are in the process of getting it. It's going to take a few more days. I will get it and file it before your lordships.
No, now you said that she is privy to all this.
Yes.
Now
I have some material to show she is
Is
privy.
her being privy demonstrable?
Yes, by her own message.
Sir.
Yes. Just and I will now get and file before your lordship. That's where, my lord, I need some time to do that.
Right.
To show that she has signed the register to enter the consulate in Dubai, Russian consulate. She has signed having received a copy of that certificate of dissolution of marriage, divorce certificate. We have applied for it, my lord. It will take a few more days to get. But this is saying that before you go, saying, I don't know anything about it. And all this is because they have suppressed this very vital fact before the learned magistrate in the complaint that has been filed. So, my lord, we will file the rejoinder, we'll serve a copy of it. And whatever they want to file, my lord, they may be directed to give us a copy in advance. It can't be that I will give it to the judge, I will not give it to you. No, my lord, it has to be given to me.
No, we'll give
Because
it.
there has to be given.
Let them
No, my lord, I want them to go on affidavit so that I can sue them for perjury.
Perjury
Let
is
them
what
go
they are
on,
going to
let
face.
them go on affidavit. Why are they fighting shy?
No, they will file.
That's fine.
They never said she will not.
No, I'm only, well, it was supposed to have been done by now. Mariland,
No. It was never part of the entire matter. It was just to show your lordships that yes, we have complaint. This is a matter that
Complaint, where is it? You have
complaint
the
was
complaint?
filed. Your lordship might have. And your lordship in this.
ನಮಗೊಂದು ಕಾಪಿ ಕೊಟ್ರೆ ನಾವು ನೋಡ್ತೀವಿ.
ಕೊಡ್ತೀವಿ.
Because there can be nothing that can be shown to the court unless I.
ಅದೇನು
Oh, will.
ಕಾಲ್ ಆ ಜಾಯಗ ಅಂತ.
Malad?
Call aa jayega, correct.
Call aa jayega.
It seems last the senior counsel was telling after the argument, have you filed a complaint and the call came?
Yeah, the message is
right,
there.
that's what's
Message
wrong
is
about it.
right there. Message is right there.
About it.
इसलिए call आ जाएगा.
Copy aa jayega. Where is the complaint, my lord?
Now, your lordship.
Malad, this is, where is the complaint?
What is this took? Kindly visit Al Barsha police station.
Correct. Based on what is given, now they have to follow up and she has to go on 7/6 to follow up with the.
7/6 is over.
Please, your lordship.
She is not gone.
Your lordship, as I. Huh? She was in India on that day, 7/6, your lordship.
Okay.
And
7/6. Oh yeah, on that day.
please, and your lordship, this is also, as I mentioned, your lordship, she's also been inquiring with her counsel because whatever it is, if proceedings begin as against her husband over there, it would be extremely difficult over there because the laws are very, very stringent there. So
Where?
whether
In Russia.
in Russia, no, in Dubai,
Dubai.
where the case is filed. Now, your lordships, with respect to whether the divorce did take place in the embassy, whether she was there or not, all of that, let them produce all of those details. But that would be completely dilatory tactics. Reason being here, your lordship, matter is with respect to a domestic violence case on which they have come for quashing. Now their claim is divorce is already done. There are dime a dozen judgments, your lordship, which says even if divorce is complete, if they are
If
able
there
to.
is any relationship
If
akin
there is
to,
any, please.
that is domestic violence will
Correct.
continue.
As I've taken your lordship towards even them living together, going on a holiday together to Maldives, all of that is anyway already there. She has very well been in India. Therefore, whether or not they would be able to evade facing domestic violence at this point of time by stating that there was some divorce that happened in an embassy where she was not present at that point of time, that would be a matter for trial. So the issue would not be at all because he is now filing that draft what he's produced before your lordship, some specific performance, your lordship. Your lordship was in fact surprised about that.
Yes.
Memorandum of petition under 34 of Specific Relief
Relief Act.
Act. Correct. So now he chooses to file this, withdraw his existing MC that he has already filed against her, which itself is now they say poor legal advice. Now too many cooks spoil the broth. That's nothing that we could do about it. Point is now Specific Relief Act draft is pending. Whether or not they are entitled to go into that aspect of that, the embassy, supposed embassy divorce is a matter of trial before either the MC court or the specific relief where they are seeking. That is when it would be final. I am before your lordship only on a simple aspect. The domestic violence was filed by her after giving 2 legal notices to him, which he chose not to respond to. Instead, he went and filed his MC. And MC notices come to me. And in that is when we come to know about all of this. He claims that there was knowledge before. That's another aspect. Now, your lordship, when divorce is filed, divorce, domestic violence, your lordship, under domestic violence, we're talking about also economic abuse. The messages are just a small token to show the kind of economic abuse he has put her through. Cut her off all access to any kind of amount that she could earn. Now she is living off her daughter who's working hard-earned money. She is working and she's living off her daughter. She's completely cut off from any kind of means to even have 2 square meals in a day, which her daughter is taking care of. Under economic also torture that she has undergone, besides the fact that he has himself admitted that he had put a gun to her head, she has filed under domestic violence. Now, whether he is entitled to seek quashing at a preliminary stage before your lordships, when the courts have even held that domestic violence cannot come under 482. 482 would come in only in extreme circumstances where unnecessary parties have been brought in into the
I
matter.
have today pronounced a judgment.
Please,
482 is maintainable against a domestic violence proceeding.
please.
It can be challenged to be an abuse of the process of the law whole hog, the entire proceeding.
Please.
If any order is challenged, appeal. No 482.
Correct.
Here, there is no order challenged. The entire, that's why first day itself I asked.
Please.
What is challenged here is not an order, the very initiation of proceedings before the court to be an abuse of the process of the law. That is what the answer
I
was.
understand your lordship's trying to distinguish, saying under section 12, if you are
See,
challenging,
section-
then 29 you have to go.
Section
I
12,
understand.
18, 17, 18, 19, 20.
Correct.
Any order passed by the magistrate, appeal under 29.
Yes.
If it is to be held an abuse of the process of the law, the sessions court does not have that power. So 482 is maintainable. That is what I have said.
Your lordship.
This is, no, because the entire proceeding is challenged here. No order is challenged.
The proceedings under section 12, what is filed has been challenged.
That's what, that is, section 12 is where you have to file only.
Correct, but
Yes.
any order as if you are aggrieved by section 12
29.
filing 29. Yes.
29. Now, no order is passed still.
Order is, they have come up challenging that notice is issued to them.
That is
And
what,
that was their
notice
urgency.
is not an order. Now, what the order, notice being issued is not under 17, 18, 19, 20. It is a notice is issued.
Your lordship.
And they are before the court saying that it is an abuse of the process of the law.
Correct.
So we will answer it under 482 itself because we can't relegate it to the court of session.
Please,
Yes.
your lordship may kindly see their prayer.
No, watch the whole proceeding if I have seen. Yes, that's the prayer, I guess. ಬೇರೆ ಏನಾದ್ರು ಕೇಳಿದ್ದೀರಾ?
Wash the impugned order dated 12/3/2024, Annexure A. The
What order is
petition and the
Entire
entire
proceedings.
proceedings. But your lordship, what is being questioned is an order dated 12/3/2024.
What is that order?
Wherein a notice was issued as
That's not
against
an
them.
order. That's not an order under 17, 18, 19.
Your lordship, whether it is under section 12 or 17, 18, 19, relief separately is under 29.
An application is filed under section 12.
Please,
Under subsection 5 of section 12, the magistrate has to answer that application immediately.
correct.
That subsection 5 of section 12 application will be filed under 17, 18, 19, 20
Yes.
for residence, maintenance, or shared household, whatever it is.
Your lordship says
Those
that the
orders-
first can go to before
yes, yes.
29, the rest they could
This
come
is here
here.
only. I have held so in the afternoon I pronounced that.
Might I just read out certain aspects where the differentiation takes
No, I'm
place, your
willing
lordship?
to say, yeah, I have to, I'm not completed my submission. I'm filing my rejoinder and I want to point out so many things. So I would request your
No,
lordship. to give
because
me
now the whole issue is, he says registering a petition before the domestic violence court is an abuse of the process of the law. It under 482. I'll answer all your submissions, I'll
Please,
answer.
please.
But what I have held,
I
so I
understood,
sent.
your lordship. That
Yes.
might, I would have to address that then. Please.
That
Please, please.
appeal antu idral baralla. Under
Correct,
29,
correct,
we'll
correct.
answer it in 482.
Correct.
If you're relying on Kamachi, the judgment of the apex court, then I've answered that.
That you
I have
also-
answered that also.
Latest other states have also held wherein.
That also I have answered.
Your answer,
Yes.
please, please.
You see the judgment in.
Please, I shall look into it. Nevertheless, they want to file some other documents which I will
No
respond
problem.
to.
Rejoinder ಏನೋ ಹಾಕ್ತೀನಿ ಅಂತ ಇದ್ದಾರೆ, ಹಾಕಿ.
And if they want, and I assume, my lord, that there's nothing more apart from this they're going to file, because it can't be every time.
You have finished your
I have
submission ಅಲ್ಲ, documentation.
documentation rejoined ಹಾಕಿದ್ದೀನಿ.
ಹಾ.
ಅವ್ರು ಏನಾದ್ರು ಹೊಸ್ತು ಹಾಕಿದ್ರೆ I have to reply to it.
So that he keep going. Tennis
Can't
match
help
will
it. I mean,
continue.
No, now rejoinder, sir rejoinder.
Sir.
That's all.
Yes.
Well, in sir rejoinder,
Ah.
if they,
Yes, wait.
sir rejoinder, if they're going to produce any new material which is not part of the material before the learned magistrate, then my lord, I reserve my right to file a sir rejoinder.
Then your lordship.
I am
could keep
entitled,
it-
my lord.
Your lordship could also say it would be subject to that interim order that was granted to them.
What interim order?
There is an interim order, your lordship. That is our difficulty. They
stay.
moved,
There is stay on
they
proceedings.
moved the vacation bench claiming
wrong about it,
urgency.
my lord? I don't think
And
we
that
can
is when
find-
an interim order came to be
Yes.
passed. Otherwise, in this
Yes.
matter, they
Now,
won't.
anyway, I am hearing the matter whole hog.
Please,
We'll close it whole hog.
please,
No problem.
please.
No problem. I mean, it can't, my lord, if the learned company, if the learned vacation court has thought it
No, there is an order
appropriate,
passed. so-
therefore it can't be, my lord, that will be found fault before you all. How did the
No, we were
vacation
not
court look at
parties
it?
at that point of time.
Not finding faults. Ex parte ಅಂತ
Ex
ಹೇಳ್ತಾರೆ.
parte.
ಹೌದು,
ಕೊಡಬಾರ್ದು ಅಂತಲ್ಲ, ಎಕ್ಸ್ parte ಅಂತ
Ex-
ಹೇಳ್ತಾರೆ.
correct, ಒಪ್ಕೊಂಡೆ. ಇಲ್ಲ ಅಂತ ಹೇಳಲ್ಲ. ಇಲ್ಲ ಅವ್ರು ಬಹಳ ವೆಕೇಶನ್ ಕೋರ್ಟ್ ಅಂತ ಎಂಫಸೈಸ್ ಮಾಡಿದ್ರು ವೆಕೇಶನ್ ಕೋರ್ಟ್ ಅವ್ರು
Correct, that's the only time that they can sneak in and file something.
case for vacation court, I don't think that can be made a grievance before this court.
That's not the, it's only a fact narration. Fact check. Yes.
ನನಗೊಂದು 10 days
Rejoinder ಹಾಕಿ.
10 days time.
Then whatever you want to do, you do. I'll hear it on 19th.
Please, Your Lordship, please.
All
19th? Yes, Vikram sir, nimdena? You're sailing with sir?
we are both together, my lord.
Yes. So.
David versus Goliath.
No, to encounter a person like you, it requires that.
Very intelligently, she was the one whom cook spoil the
ಇಲ್ಲ ಅದಕ್ಕೋಸ್ಕರ ಇದೆಲ್ಲ ನಾವು
I got the statement. What should
No, no,
I-
that is
I-
also for senior said.
That
last
is for the
time it was
advice.
wrong advice. Now they have good advice, so.
good or bad or indifferent or
Whatever. We'll do it.
whatever. Ultimately, what the court says is right.
All in the lighter way.
I know. Of course.
Because otherwise you can't break the monotony.
Undoubtedly, my lord.
It's difficult to be serious throughout the day.
ನಮಗ್ ಪರವಾಗಿಲ್ಲ ಇಲ್ಲ ನಮಗ್
Fine,
ಪರವಾಗಿಲ್ಲ ನಾವು ಕೋರ್ಟ್ ಹೋಗ್ಬಿಟ್ಟು ತಮಾಷೆ ಮಾಡ್ಕೊಂಡು ಹೊರಟೋಗ್ತೀವಿ. Your lordships enjoyed it for some time and your lordships gave it up voluntarily. Therefore, my lord, applying the tort principle, voluntary non-fit injuria. Grateful.
Yes.
The
Take
injury
it on
part has to
19th.
be extended, my lord.
Heard the learned senior counsel K.G. Raghavan and learned senior counsel Vikram Huligold appearing for the petitioners and counsel Srimati Lakshmi Iyengar representing the respondent at length. The learned senior counsel would seek to file his the petitioner would seek to file his rejoinder to the statement of objection so filed by the respondent, and the respondent seeks time to file a surrejoinder to the rejoinder so filed by the petitioners. The pleadings be complete by the next date of hearing. List the matter on 19th at again 3:30 PM for further hearing.
Grateful. The interim order.
Interim order subsisting shall continue till the next date.
Subsisting from the time of vacation.
Subsist.
Grateful.
Yes. Pasha sir. Settlement ಇದೆಯಾ? ಎಷ್ಟಿದೆ? ಎರಡಿದೆ. ಹಸವಂತ್ ಪಾಷಾ ಸರ್, ಒಂದ್ ನಿಮಿಷ, ಒಂದ್ ಸೆಟಲ್ಮೆಂಟ್ ಇದೆ, ಮುಗಿಸ್ಬಿಡ್ತೀನಿ.
Orders at 4 PM, 132 settlement, 132.
Offense.
Offense, my lord.
Section 6 of the POCSO Act, please.
376.
The age of the victim, she was 16 years, 10 months.
What happened, my lord? The father is also an accused here. Father, mother of the victim is also accused, number 7 and 8.
ನೀವು 4 and 6 ಸೆಟಲ್ಮೆಂಟ್ ತರಲೇಬೇಡಿ. If they are married, children, ಆ ಥರ ಏನಾರಿದೆ circumstance, otherwise don't bring 4 and 6. What's the age of the accused?
Age of the accused.
24 years. please.
They were in love.
They were married, my lord. Arranged marriage.
Arranged marriage.
By the parents.
Arranged marriage.
Please.
9 to 20.
Where are they from?
My lord, the
Boy is from Madanapalli, Andhra Pradesh. And the girl
He's
is
in
from
judicial
Devanahalli.
custody?
No, my lord. Everyone's on
Outside.
bail. Please.
major, my lord. But marriage is on 9/9/2021, my lord. The complaint came to be lodged on 23 after lapse of 2 years, my lord. Some photos. The photos.
Jagdishwar, you should, both the additional SP people should decide something about all this. Situation.
Victim.
Both are married. After marriage, they were found.
But 8 months they are together. Thereafter, my lord, she went to her parents' house. They not lodged a complaint. After 2 years, my lord, complaint came to be lodged.
After 2 years?
2 years, my lord. That
Please.
is the case.
When she became pregnant?
No.
No.
Thing.
See, the
Who lodged the complaint?
the
victim herself.
only, my lord.
Why?
There's a misunderstanding between the both of them, my lord. Even, my lord, some photos, marriage photos, my lord. The father is victim father is accused, my lord. Victim father, mother is also accused here.
No, victim father and mother, we will stay. That's a different thing.
Even the parents of the victim are parties. And
Accused also.
accused
Yes,
is
they
also the
participate.
party.
Allah, idya
Well, before my lords.
ಎಲ್ಲ
why
ಮದುವೆ
such complaint against the in-laws, her own father and mother?
They were cited in charge sheet after investigation.
No, marriages happened before, but they are nonetheless married today. And charge sheet is filed against both the parents of victim and
Yes, ma'am.
accused. No, not for child marriage. She has herself filed, I believe. She was 18 or 19 when it was filed.
18 years. please.
But the settlement hang kastala. Why do you get them without 4 and 6 will have to think over and do it. It's not that easy. Next Friday ಇದೆಲ್ಲ ಹಾಕಿರ್ತೀನಿ. 3-4 ಇದೆ. See, ಬೆಳಗ್ಗೆ I have settled it saying 2 children are there, one a 2-month baby and another boy. And she's 24 years now. proceedings are going on, I've quashed it on settlement. ಇದೆಲ್ಲ ಮಾಡಕ್ ಸ್ವಲ್ಪ ಕಷ್ಟ. Thursday.
Even in this case, the matter is being set down for charge.
Thursday ಹಾಕ್ತೀನಿ.
Please.
List the matter on Thursday, Madam, Wednesday, sorry, 4th. List the matter on 4th July in the fresh at 2:30 PM. A learned counsel submits that the matter is set for charge. The concerned court shall defer framing of charges till the issue is decided by this court.
Okay, take care of that.
ಈಗ POCSO cases ಅಲ್ಲಿ the prosecution is saying, come what may, conviction is the only thing. That's ಸ್ವಲ್ಪ it's not correct. Well, Act says you should not always think, ground reality you should think. ಈಗ ಅವರಿಬ್ಬರು ಕ್ವಾಶ್ ಮಾಡಿದ್ರೆ in judicial custody, if the husband is there, how will the wife handle 2 kids and run her life if the man is inside? This is also she was 17 years when that happened. You know, there was 17 years, 11 months, and the man is inside. These are the hard realities we'll have to think over. ನಿಮ್ದೆ ಇದೇನು?
17 years, 11 months. Last occasion.
ಇದು POCSO.
Yes, POCSO. Last occasion directed us to register the marriage. Marriage is
DNA ಮಕ್ಕಳಾಗಿಲ್ವಾ?
Conceive kept
ಈಗಾಗಲ್ಲ.
remains. 4 months she is running.
17 years, 7 months ಇದೆ.
ಅದೇ 17 years, 7 months. See, what do you do with these cases? No, in 17 years, 7 months, the girl is carrying and the husband is in jail. ಅವು ಏನಾಗುತ್ತೆ ಅವ್ರ ಗತಿ? Law is that what to do? Very difficult. Now it is 17 years and all these cases, 17 years and 21 years, cases of love. Majority of them are cases of love. And 21 years you put him behind bars for this action. No, that is there. You will be in trouble. That's there. That is important. We'll see. Idu Friday, Thursday next. All these settlement matters will take on Thursday. Just think over it.
Till then, my lord, the police authority is
Custody ಇದರ?
custody illa. He is in outside.
ಸರಿ, ಏನಾಗಿದೆ ಕನ್ಸರ್ನ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ?
Please.
ವಾಟ್ ಸ್ಟೇಜ್?
ಅಲ್ಲ ಸ್ಟೇಜ್ ಇಲ್ಲ, ಬಟ್ ಪೊಲೀಸ್ನವರು ಡೈಲಿ ಎವ್ರಿ ಡೇ ಕಾಲ್ ಮಾಡ್ಬಿಟ್ಟು ಬನ್ನಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ತಗೋಬೇಕು ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅರೆಸ್ಟ್
ಕಾಲ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ವಾ?
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿಲ್ಲ.
ಕಾಲ್ ಮಾಡಬೇಡಿ.
ಅಲ್ಲ ಸ್ಟೇ ಬಟ್ ಇವತ್ತು ಅಷ್ಟೇ ಎಸ್ಟರ್ಡೇ ಆಲ್ಸೋ ಈ ಕೇಮ್ ಹಿಯರ್.
Till Thursday, the respondents are restrained from taking any coercive steps or precipitating the matters.
Please.
Yes. As the matter is moved for settlement and this court is now seized of the issue whether the matter has to be settled and the matter has to be quashed by way of by way of accepting the settlement or otherwise.
I am permitted to produce the registered certificate of marriage. Memo.
Memo ಹಾಕಿದ್ದೀರಾ?
Please.
ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ ಫೈಲ್ ಮಾಡಿ, ಸೀಲ್ ಆಗಿ ಬರಲಿ.
Please.
Yes, list on Thursday.
Passport 87.
28. Sawmill. Did you see? See sawmill. Wait, finish. Senior ಬರಕ್ ಹೇಳಿದ್ದ. We'll refer this to FSL.
No, my lord, there is no admitted handwriting here.
Admitted handwriting, you said will produce.
No admitted.
Yes, your lordship directed me not to bring it here to give it to the officer. That is.
No.
Yes.
My lord, here the question, my lord, you are not knowing what is this letter. This letter was not the part of charge sheet. My lord, we verified this. My lord, this notebook, what is produced, my lord, here, my lord, could not be subjected for comparison because there is no specimen writing for comparison in English.
That is what your
Now
lordship
also, if that is not available, to whom to refer? What for comparison?
Then we'll direct further investigation.
What further investigation, my lord, is not required at all.
No,
My lord, investigation is done. In respect of this document also, investigation is done.
No,
But
this document, what is produced now,
Yes,
there is no
it is
investigation.
now verified, my lord, it is part of investigation record only.
Which one?
My
This
lord,
one?
Yes, this copy was not given to us.
Which copy, sir?
This no, my lord, a diary, my lord, what it is now in English, my lord.
Now,
What it is
the senior
produced, my
counsel
lord.
produced
Yes,
in
it was,
English.
it was
That's a part of the investigation.
of investigation. We got verified, my lord, that
Thank you.
they have verified it. My lord, the officers have verified, they could not
It
trace.
is part of the
Yes,
investigation.
yes, it's, my lord, it is noted in the order sheet also, in the trial.
That
court.
is what the order sheet, trial court order
Yes,
sheet.
yes. There. Lordship said,
Then it saves of many, many things.
yes, my lord, cannot be referred at all, it is.
Yes,
And they have investigated with
one
respect to
nimsham.
this.
I'll come back. Page, part of the order sheet.
Yes. Sir. My lord, kindly page 32, my lord. 32, lordship, of our petition.
132, sir.
Yes. My lord, on this day, 8/1/19, my lord, before the trial court, the investigation officer or a police constable.
Oh, yes.
Yes.
He is producing the notebook seized.
She is
In this case, as per item 2 and 8 in PF so and submits the documents produced are sent to FSL for scientific examination. Please, oh, everything is done.
All it is done,
My
it is,
friend,
now records
like-
is available. My lord, their own production, my lord, Hindi.
No, it may not be required.
Yes. My lord, therefore yesterday I was not knowing that.
Yes, yes,
Yesterday we got verified.
No,
the trial
because
court
senior
record.
counsel said in column 18, it is a part of the charge sheet and part of the document seized and nothing comes about on
No,
that.
no, it has been. done,
So
my lord.
it is, now I can take it that it is a part of the charge
It is
sheet.
part of the.
Whether
charge
it is
sheet.
considered or not, I will see.
Yes.
Yes.
Lordship, my lord.
Your lordship, to differentiate, now what they stated that this was given, two different people have
So
given
now
two
senior
different.
counsel is accepting that these letters were a part of the charge sheet.
Correct. Now,
So leave it.
now what happened is, there is one supposed Hindi written letter. To match that, what they give is two chits, as he's referring to. Two chits written by Turdal, Mungdal, whatever, those two chits.
Turdal,
That is,
Mungdal,
yes, her
Turdal,
slips,
Mungdal.
slips to purchase in the shop,
Ah.
what her mother-in-law has written or she supposedly asked her to write, that is set for comparison with that supposed Hindi note. The English diary is conveniently kept aside. Now, what they're trying to make out is, this should have some comparative note in English, and therefore, that is what I said, I
So
will
that's
give
all right.
something
Now
else,
it is a part of the investigation papers.
which has not
That-
gone to FS.
That we'll see.
Yes.
Part of the investigation papers we'll see.
But
So
here.
I need not again refer it to FS.
Yes, my lord, your lordship may kindly see page 126, my lord, PF it is. My lord, this complainant, my lord, father of the victim, my lord, he has produced 3 documents, your lordship. Your lordship may kindly see page 126.
I'm at 126, sir.
Page, yes, my lord, page 126, my lord, PF number 92.
Yes, 92.
ಒಂದು ಬಿಳಿ ಬಣ್ಣದ ಪೇಪರ್ನ ಚೀಟಿ ಅದರಲ್ಲಿ
ಇದೆ.
3 ಸಾಲಿನಲ್ಲಿ ಹಿಂದಿ ಭಾಷೆಗೆ ಬರವಣಿಗೆ ಇರುತ್ತದೆ. ಬರವಣಿಗೆ S1 ಮತ್ತು S2 ಅಂತ ಮಾರ್ಕ್ ಆಗಿದೆ. ಅಲ್ಲ, this S1, S2 produced by complainant, that is father of the deceased, was referred, my lord, as a
FSL.
specimen writing for comparison with this, my lord, death note page produced at 174. It is got confirmed, my lord, the expert has confirmed it. The Hindi writing as a specimen writing produced by father of victim is tallied with the death note left at
It
the
was
spot.
not sent to FSL because there was no
admitted
comparative.
writing. No admitted writing, my lord, that it is required. A specimen is required. Even now they are unable to produce.
No, I will produce it right away. It was sent to me. I had specifically told them, and I asked your lordship, I'll produce it here. Your lordship said, give it to the officer.
Now
And
the
that is why
question,
we
my
did.
lord, that no,
Your
at
lordship,
this
Now,
stage,
keeping this petition pending, let
Yes.
that also be.
here, my lord, that again, my lord, that when
No, so it can be doubly sure that it is the handwriting of the victim or not,
No,
or the deceased or not.
yes.
not the stage of investigation, my lordship, that we have come up, my lord, a petition, my lord, seeking the relief of quashing of the proceedings of the court below. My lord, if they are aggrieved, my lord, they have to, my lord, resort to
In
the
our
remedy
petition,
available.
I can't do that.
Yes. Now, my lord, that my submission, my lord, that the proceeding, my lord, what it was, now where it is, and as it is, my lord, your lordship has to consider the material.
All right.
No, with this, my lord, that what I submit, my lord, I am filing a memo, my lord, that I am withdrawing this petition.
Withdrawing?
Yes.
Why?
My lord,
What's the argument?
I feel, my lord, that it is better.
All right.
Your lordship, the prosecutor's been wanting a word in since then, your lordship.
Yes.
The
paperboard diary that they are referring to, your lordships, is part of the evidence. That has not been sent, your lordships, with the IO.
But anyway, sir is saying he's withdrawing the
We
petition.
will withdraw this petition. We are not pursuing.
ಅಷ್ಟೇ withdrawal simpliciter. But anyway, ಈಗ now we have withdrawn, now only to get.
Nothing to highlight now.
No, no,
that we are-
it bit off the case.
Well, it is a matter
Now,
for
in-
trial court will
No,
adjudicate
all that
this.
is true, sir. Now I am asking for my information. In a given case, now this court cannot refer any matter to the FSL saying you get the disputed signature verified and I'll keep the petition pending. That can be done under 482.
That is here, it is.
Not in this case, in
Yeah.
general,
It can be done,
can be done. 482 power is not restrictive that way.
can be done. My lord, under section 73 of evidence, court itself can examine it.
Yes, that's what.
That power is there.
Yes.
My lord, but under 482, my lord, to secure ends of justice, this order.
So it is
can be passed.
unlimited. Yes. Withdrawn. The learned the advocate on record files a memo seeking to withdraw the petition. The memo for withdrawal reads as follows. Petition is dismissed as withdrawn.
Disposed of. and,
Disposed as withdrawn. Yes.
obliged.
Complainant reserves liberty to approach the IO for.
Any,
that
it
is
is
not-
withdrawn,
not- it is about
everything is
petition.
open.
Yes.
You can do anything.
Obliged.
Seesaw mill.
Yes.
89. ನಿಮ್ದು ಯಾವ್ದು ಶ್ರೀನಿವಾಸ್ ಅವರೇ?
ಪಾಸ್ ಆಗಿ 4 ಗಂಟೆ ಕರಿತೀನಿ.
Okay, okay. Domestic violence.
ಹಿಯರ್ ಮಾಡ್ತೀರಾ ಇಲ್ಲ ನಾನು ಫುಲ್ ಅಂತ
520. Anyway,
date.
can you
My
come on
lord, I
another
have-
day?
I have filed an objection.
To this?
Yes,
You are ready?
yes.
Tell me. Yes, yes, sir. Really?
ಹೇಳ ಲೇಟ್ ಆಯ್ತು ಅಂತ.
Does this have any bearing to the other petition which I have pronounced? ಇದ್ರಲ್ಲಿ ಏನ್ ಹಸ್ಬೆಂಡ ಇನ್ಲಾಸ?
ಹಸ್ಬೆಂಡ್
Only husband.
ಓನ್ಲಿ
ಇದ್ರಲ್ಲಿ only husband.
ಓನ್ಲಿ
All right.
ಒಂದು 8-10 ಸೆಂಟೆನ್ಸ್ ಹೇಳ್ಬಿಡ್ತೀನಿ, ಇದಕ್ಕೆ ರೆಲೆವೆಂಟ್ ಏನೋ ಅದು ಮಾತ್ರ ಹೇಳ್ತೀನಿ, ಹಳೇದೇನು ಹೇಳ್ಕೋಲ್ಲ.
This may be sustainable.
Let me present my arguments.
Then it's 5:30 now.
My lord, I want to
Monday ಅಥವಾ
submit,
One minute.
I want to submit one thing. He has told me to enlarge my vagina by fingering myself. And I have an audio recording of that. That is a physical torture. And he has abandoned me, that is a mental torture. And he has asked me to transfer my savings, around 30 lakhs of savings. But that has not been done by me.
This we will hear, madam.
My lord,
Tuesday?
expedite the trial, my lord.
Tuesday.
Tuesday ಅಲ್ಲ, Friday.
ಬೇಡ. ನೀವು ಇಲ್ಲ ಅಂದ್ರೆ Tuesday. When can you come?
Yes, my lord.
Friday you can come?
Date, my lord.
For next 5th.
Oh, my lord, I have some other
When are you free? Tell me.
Tuesday.
ಬಂದ್ಬಿಡಿ Tuesday. You're not in town?
ಇಲ್ಲ ಇದೀನಿ,
Then
ಎಲ್ಲ 4-4 ಡೇಟೆಡ್ ಮ್ಯಾಟ್ರ್.
come on Tuesday, ಸಾಯಂಕಾಲ. I'll take it at 4 o'clock.
4 o'clock.
I will come only at 4 o'clock.
Thank you.
Much obliged. Interim order may be
Extended.
please.
ನಿಮ್ದೇನ್ sir?
In the presence of police officer or the forest officer, not by the complainant. Again, it will create some nuisance in the. After all, he is a president of some Sene. He comes to the, while opening this.
ಅವರೇ ಟೇಪ್ ಕಟ್ ಮಾಡ್ತಾರಂತೆ. ಅವರೇ ಟೇಪ್ ಕಟ್ ಮಾಡ್ತಾರಂತೆ. ಓಪನಿಂಗ್ ಸೆರೆಮನಿದು ಟೇಪ್ ಕಟಿಂಗ್ ಅವರೇ ಮಾಡ್ತಾರೆ.
I have objection for his presence. The local police also along with the police office, the forest officers.
And we will do a mazar, proper mazar.
Now, you do one thing.
Yes.
Tomorrow, you conduct a mazar
Yes.
of the unit.
Yes.
And place that mazar on Monday before me. If wherever seized material is there, you identify, and where that should be kept, you just have take note of it. Open the sawmill from Monday or Tuesday, whatever it is. Monday you place the Maser, I will permit by detailing, giving some guidelines, I will do it.
Yeah.
Monday open ಮಾಡ್ಸೋಣ. Weekend ಹೋಟ್ಲಾ ನಿಮ್ದು weekend ಅಲ್ಲಿ ಕೆಲಸ ಆಗಕ್ಕೆ?
We'll start it tomorrow.
Yes. Monday. Affidavit ತಗೊಂಬನ್ನಿ ಅಷ್ಟೊತ್ತಿಗೆ.
I'll file it in the counter tomorrow.
ಮಾಡಿ.
I have the draft.
Why should I see the draft? You file it in the counter.
Yes.
With
The
Maser with the videographer.
ನಿಮಗೆ ಪೆನ್ ಡ್ರೈವ್ ಕೊಡ್ತಾರೆ, ವರಿ ಮಾಡಬೇಡಿ. The learned additional SPP is directed to conduct a mahzar of the sawmill that is now under lock and key, i.e. seized, tomorrow at 3 p.m. The mahzar that is drawn be placed before the court on Monday. List this matter on Monday at 4 p.m. The mahzar admel note ಹೇಳ್ತೀನಿ ಏನೇನಿದೆ ನೋಡ್ಬಿಟ್ಟು I'll take it at 4 p.m. By then you file an affidavit also. Okay? ಇನ್ನೊಂದ್ಸರಿ ನಿಮ್ sawmill ಕ್ಲೋಸ್ ಆಗಬಾರ್ದು ಅಂದ್ರೆ ಮಾಡಿ. Yes. ನೀವು PIL ಆಗ್ತೀರಾ? Yes.
Later part.
Later part.
And to celebrate the success.
PIL.
Anyhow, you are wanting to close this sawmill.
Not only for this, as rightly pointed out by you.
There are
a lot of
concerns, I think.
ಸಾಕು. Come on. So ನಾಳೆ ಮಾಡಿಸಿ ಅದು Monday 4 p.m. ತಗೋ.
Also, respect of serial number 71, Lordship has passed the entry order.
क्या entry order?
To stay the remand application, serial number 71.
ಕೊಟ್ಟಾಗಿದೆ, ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಆಯ್ತು, ಅಪ್ಲೋಡ್ ಆಯ್ತು.
ಆಗಿದೆ, ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕನ್ಫ್ಯೂಷನ್ ಆಗಿ ರಿಲೀಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ರಿಲೀಸ್ ಮಾಡ್ತಾ ಇಲ್ಲ petitioners ಗೆ, ಯಾಕಂದ್ರೆ ಅದು ಎಂಟ್ರಿ ಆರ್ಡರ್ ಕೋರ್ಟ್ ಮಾಡಿ ಅಂತ ಡೈರೆಕ್ಟ್ ಕೊಟ್ಟಿದ್ರು. ಎಂಟ್ರಿ ಆರ್ಡರ್ ಕೋರ್ಟ್ ಆಗಿಲ್ಲ ಇದ್ರಲ್ಲಿ. ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ
ಕೋರ್ಟ್ ಆಗಿಲ್ಲ. What do you mean ಕೋರ್ಟ್ ಆಗಿಲ್ಲ?
ಆಗಿಲ್ಲ. ಎಂಟ್ರಿ ಆರ್ಡರ್
ಅಪ್ಲೋಡ್ ಆಗಿಲ್ವಾ?
ಅಪ್ಲೋಡ್ ಆಗಿಲ್ಲ ಅಲ್ಲ, ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಸಿಕ್ಕಿದೆ. ಎಂಟ್ರಿಮ್ ಪ್ರಯರ್ ಏನಿದೆ ಅಂತ ಎಂಟ್ರಿ ಮಾಡಿ
ಇಂಟ್ರಿಮ್ ಪ್ರಯರ್ ಕೋರ್ಟ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದೆ ನಾನು. ಯಾಕೆ ಯಾರ್ದು? It specifically told what is the interim prayer. We will correct it and upload it now in 10 minutes.
Please.
ಯಾರು ಎಸ್ಜೆಕೆನ ಫೋನ್ ಮಾಡಿ ಇಲ್ಲಿ ಲೀವ್ ಆಫ್ ಈಗಲೇ ಮಾಡಿ.
Your Lordship, matter pertaining to Kalburgi bench, Your Lordship, election.
ಇದೆಯಾ ಇವತ್ತು?
ಇವತ್ತಿತ್ತು, Your Lordship.
Which one? Election na?
Election petitions, serial number 2, Your Lordship.
Next week ತಗೊಂತೀನಿ 5:30. Yes. Election petition will
I've
start.
complied with your previous order, Your Lordship.
Yes.
May be taken up next week.
5th I'll take.
Much obliged.
Court officer? Court officer? Madam? Court officer? Court officer? Madam, Kalburgi bench matters ಯಾವಾಗ ಅಡ್ಜನ್ ಆಯ್ತು ಮೇಡಮ್?
ಸರ್ ಟೇಬಲ್ ಗಿಡೋದು ಯಾರು ಅದು ಹಾಕೊಳ್ಳೋಕೆ ಕೇಳ್ತಾ ಇದ್ದಾರೆ ಸರ್. ಅದು ಹಾಕೊಳ್ಳೋದು
ಮೇಡಮ್ ಕಲಬುರ್ಗಿ ಬೆಂಚ್ ಮ್ಯಾಟರ್ಸ್ ಮೇಡಮ್ ಕಲಬುರ್ಗಿ ಬೆಂಚ್ ಮ್ಯಾಟರ್ಸ್ ಯಾವಾಗ ಅಡ್ಜನ್ ಆಯ್ತು?
ಸರ್ ಹೇಳಿ ಏನ್ ಸರ್ ಹೇಳಿ.
ಕಲಬುರ್ಗಿ ಬೆಂಚ್ ಮ್ಯಾಟರ್ಸ್ ಯಾವಾಗ ಅಡ್ಜನ್ ಆಯ್ತು ಮೇಡಮ್?
ಕಲಬುರ್ಗಿದು 5th ಗೆ